Today to continue the inquiry into the application under Section 36 of the Electricity Act 1989 by North Lowther Energy Initiative Limited for a wind farm. I have been appointed by Scottish ministers to hold the inquiry and thereafter report to them the recommendation on whether to approve or refuse the application. Now, again, before we begin, a few points of administration for those who haven't been here before. Toilets are out the hall on the left. There's no fire drill today, so if the alarm does go, please leave by the nearest exit and congregate outside the front of the building. If you have a mobile phone, if you keep that switched off or on silent during today's discussions. Please watch yourself. There are some wires in the ground that you don't trip as you go around. You'll note that we are being filmed today. This allows an opportunity for those who cannot attend to review the proceedings. To enable the system to work effectively, you need to use the microphones by pushing the button, and the indicator will come on red to show it's on, and push it again once you're finished to switch it off. The exception to this, I suggest, is that the ornithology session this afternoon, or this morning, depending on progress, is not broadcast. This is because the material discussed could be confidential, relating potentially to the location and number of protected birds. Are parties in agreement that that particular session is not filmed?
Sir, obviously a matter for you, but that probably would be prudent because it may be that a question or an answer inadvertently gives information that shouldn't be disclosed. It's probably safer not to record any of it, just in case.
You're
yes,
happy with that?
We're in agreement with that.
Now, on that topic, you'll see me talking with my colleague Ewan, who's in charge of filming and audio during proceedings. Ewan has no involvement in the decision-making process, and any discussions we have will not influence the outcome of my report and recommendation. Now, can everybody hear me clearly? Brilliant. If you have any difficulty during proceedings, please let me know. Now, can I confirm those participating in today's inquiry sessions, those leading and giving evidence, starting with the applicant?
Good morning, sir. Our intended order of witnesses is as follows: Mr. Bone, who's at the witness table just now, then Mr. MacArthur, then Mr. Moody, and it is hoped, with a fair wind, that these three could be finished by lunchtime, which would enable Mr. Bell to give evidence on planning matters this afternoon. That is far from certain, naturally, but that is the hope.
And from the One Lockhead Village Council and Lead Hills Community Council?
Mrs. Gibb will be giving evidence on the contamination issue, and I'll be giving evidence in relation to ornithology and impact on heritage and culture.
Thank you. Now, my understanding is we'll go Mr. Bone and then we'll go Ms. Gibb on contamination, and then we'll go, as it were, the applicant's witness followed by the witness for the other side. That's agreed?
That's what I'd understood, sir.
Okay, for those of you that haven't been here during the inquiry sessions to date, inquiries are a formal process to ensure that everyone discloses their cases in advance, to avoid ambushing and to bring structure and rigour to the process of information gathering and discussion that will take place here today. The evidence will be given by the witness appearing for each party. Each witness will read their precognition. When giving evidence, the witness will sit at the table here. The witness will then answer questions posed by those leading the other side. Those with the same stance cannot question people on the same side to improve their case, but they can seek clarification if something isn't clear. Questions may relate to any aspect of the full precognition and the documents on which the evidence is based. I will also ask questions if I need further information. Particular points may be clarified after cross-examination has taken place. The purpose of the inquiry session is to enable me to obtain the evidence relevant to the proposed development so that I can make an informed recommendation to Scottish ministers. Those asking questions should focus on this purpose. I'm not interested in point scoring or needless argument. I'll intervene if I think either the evidence or the questions do not assist me. In addition, there are witnesses, you should avoid repetition. Now, there are a few procedural matters just to cover from yesterday. One was to do with the additional document submitted by Mr. Godfrey in terms of the Golden Eagle project. Is that document accepted?
Yes, I believe it is, sir. Thank you.
And just for my note, I think we agreed the chronological table that was submitted by SNH. Is that correct?
Yes, that is so, sir.
And do you have any comment in terms of the updated table? That was a table that wouldn't contain any new information, which would provide the findings of Dr. Wimble, Mr. Van Grieken and Mr. Welch in a table of significance.
Well, in truth, we haven't discussed that in detail yet, sir, because that would involve the two landscape witnesses. So perhaps, I think the fault for that is mine. I perhaps should have phoned them last night, but I'm afraid I rather forgot. Perhaps I can come back to you on that one later. And just to assist, perhaps if somebody could make contact to see if we could provide that table in early course.
So maybe both sides don't need to produce the same table. I've asked Dr. Wimble to have a go at it. I haven't had a response from him yet, because it's effectively Mr. Welsh's table, as I understand it, with suitably adjusted to reflect the things that you mentioned, most of which will probably be coming in from Dr. Wimble. So it should be capable of being done, and I'm sure that landscape consultants can work together on it.
Well, that'd be appreciated if you could coordinate a response and maybe submit the table tomorrow if possible.
We will have both our witnesses, landscape witnesses, here tomorrow, sir. So it may be, if there's any discussion to take place, that could be done tomorrow morning.
So I just think getting a fully agreed table tomorrow may be asking a bit much from the three parties concerned, because I think, as Mr. Welsh, for instance, would freely admit, there's a lot of detail in the table, and they would no doubt wish to check it and recheck it before it was submitted as an agreed document. But we'll do our best. Okay,
I mean, there's nothing new which I've requested, so I mean, it could come after the inquiry as a document of fact, but we can discuss that tomorrow. Now, we'll proceed to the inquiry. Are there any questions from anyone before we proceed? No, in that case, I'll ask Mr. Steele to take his first witness.
Thank you, sir. The next witness is Mr. Bone. We have a precognition and an inquiry report, sir, and we intend to take much of the precognition as read and refer to one or two paragraphs, actually I think three it is, in the main report, in light of criticisms by Mr. Mundell, which we say are unjustified, that we have taken no account of objections or concerns expressed by others. So if I may proceed on that basis. Mr. Bone, could we go straight to your introduction, and if you could read that out just to make sure you can work the microphone, Mr. Bone, and then we'll get into the merits of the matter.
Thank you, Mr. Seal. May I just check that everybody can hear me? Yes. Good morning, all. Referencing my precognition chapter, my precognition report, section paragraphs 1 to 5, I am Stuart Bone. I'm employed as an associate and a team leader in the water specialisms group within WSP. I was previously employed in a similar role by Michelle during 2016. I'm a chartered water and environmental manager and also a chartered environmentalist. And I have been directly involved in the design, data collection, assessment and reporting process for the NLEI scheme since June 2016, with my role including the coordination of technical teams, providing input relating to civil engineering design and EIA report assessments of surface water, groundwater, peat and mining history. I was directly involved in the FEI, further environmental information process, additionally coordinating amendments and preparing those additional documents. My detailed evidence inquiry is provided within the Flooding and Contamination Report, NLEI 12, which also addressed the combined objections of Lead Hills Community Council and Wanlockhead Village Council in respect to the hydrology, hydrogeology, geology and soils deliverables for both the EIA report, the FEI document and all associated technical appendices and figures. I would then like to discuss some other elements within the precognition.
Can we then turn to paragraphs 9 and 10? I think you'd like to read them out, Mr. Bone.
Yes, Mr. Steele. So these items relate to flood risk at Wanlock Head, which had been raised by the Lead Hills Community Council and Wanlock Head Village Council. And what we're saying in paragraph 9 and 10 is that surface water flows from the development site do not flow into Wanlock Head, with the village located upstream of the proposed infrastructure. Therefore, flood risk in the village shall not be adversely affected by the NLEI development.
That would be a physical impossibility, I take it.
Yes. Surface water flow from the site should be designed as per good practice to attenuate flow increases in the downstream channels, but again, to reiterate, these do not flow through Wanlock Head village.
Now, are there any other paragraphs of your precognition you'd wish to read out before turning to look at the conclusions?
No, I think we could go straight to paragraphs 29 to 33.
If you just read them out, please.
In conclusion, in paragraph 29, I state the Flooding and Contamination Inquiry Report, core document NLEI 12, provided a detailed response to the Lead Hills Community Council and Wanlock Head Village Council concerns and background information to support the planned approach. These issues have been taken into account within the design of the NLEI development, within our technical assessments, and during all consultations with the Scottish Environment Protection Agency and Dumfries and Galloway Council. My submission provided further detail on post-consent soil and water data collection, outlines a methodology for using site data to determine runoff treatment requirements, and identifies proven sustainable drainage system technologies to potential mitigate mobilisation of heavy metals. I've also summarised third-party research, aspects of the regulatory regime and project compliance that will ensure adherence with good practice in terms of site environmental management. In paragraph 31, I consider the predominant local water quality risk related to the deteriorating status of historic mining features in the upper Wanlock Water Valley, and a multi-agency remediation project for the former mine workings of this area is not considered to lie within the scope of the NLEI project, as the NLEI project will have no influence on these features which are out with the development area, as has been recognised by the statutory bodies. However, environmental data collected and reported for the development shall be made freely available to SEPA and appropriate third parties, providing beneficial information funded by the developer that would inform any mining legacy remediation plans that do lie out with the development site, including for the upper Wanlock Water Valley. In conclusion, paragraph 33, no adverse significant impacts are predicted on any hydrology, hydrogeology, geology or soil receptors, and this point is emphasised by the lack of objection by SEPA or Dumfries and Galloway Council in relation to this technical discipline.
And Mr. Bone, is it important to realise that SEPA are the appropriate regulator here, and everything will have to be done to meet their requirements and get their agreement?
Yes, SEPA will insist on a construction site licence for this development, along with other environmental permits, all of which will require prior approval before any earthworks or other construction activities may commence.
So that it's not just a question of taking your word or our word for it, SEPA will regulate appropriately.
That is correct.
Thank you. Could we then look at your inquiry report, please? As I say, these are simply points in response to Mr. Mundell, who unfortunately is not here this morning. Could you look, please, at page 6, under the heading ES Design Considerations, and could you read out that paragraph?
Yes. Detailed constraints advice was provided during the environmental statement iterative layout design process for both turbine and associated infrastructure features. At a number of stages during the iterative design process, fieldwork was undertaken to provide further localised information to the development design. I attended a number of multidisciplinary design workshops to ensure relevant features were all understood and recognised within the design process, and this approach minimised a number of potential effects.
You there list, but we will not read out in bullet points various constraints that were considered.
Yes.
If you can turn to page 7, please, the paragraph, I think it's the third one, the data gathered, etc. Could you read that one out?
Of course. The data gathered with regard to historic mining and soil and water analysis informed the design process, and infrastructure has not been planned in areas identified of either moderate or high risk. This included the removal of a potential access track linked to the B797 to the south of Wanlockhead, which was formerly known as Access C.
If we could then turn the page to page 8, FEI design considerations, and were they made in direct response to a number of concerns or objections that were raised?
Yes, they were, Mr. Steele. Following feedback from consultees, including Leith Hills Community Council, Wanlockhead Village Council and others, a number of design updates and additional commitments were made in 2018. Those most relevant to the objections were as follows: the deletion of turbines 10 to 14 with associated access tracks and ancillary infrastructure, alteration of the development boundary to exclude former mine working areas where infrastructure was not proposed, additional peat slide risk assessment data and associated specific mitigation, and a commitment to undertake further soil and water sampling and analysis to inform the construction phase soil management and drainage design in relation to potential mobilisation of heavy metals.
Mr. Bone, from your point of view, from your expertise, if anyone suggested that we had no regard to concerns that were expressed, would that be accurate or inaccurate?
That would be inaccurate.
For the reasons that you set out there?
For those reasons.
Yeah. And finally, can we turn to page 14, and I think you wish to draw reference to the Coal Authority document.
Yes, we're aware that of the July 2016 Coal Authority document that's been quoted by Leith Hills Community Council and Wanlockhead Village Council as core document 10.34, which evaluates benefits to cost ratio for potential remediation works in Wanlock water. Based on information provided by the Coal Authority and other third parties, the specified locations of concern, such as the Bay Mine Discharge, Glenglass Level Discharge, Queensbury Tailing Pond and Glencreef Tailing Pond, were all identified as development constraints, and these were all avoided. These specific sources are considered the primary contributors to Wanlock water metal loadings and do not lie within the NLEI site boundary, nor will be influenced by the proposed infrastructure, as there is no hydrological linkage between the site and these locations.
So, in short, are you saying that the proposal will have no effect on the areas that have been identified as being of concern?
That is correct.
Fine, thank you. I have no further questions, Mr. Bowen, but you're now available to answer some questions.
Thank you. Now, I'm not sure who's going to be asking the questions. Is it a mix of the two of you, or just yourself, Ms. Gibb? Yourself, Ms. Gibb. Okay. If you'd like to continue through cross-examination.
Mr. Bowen, thank you for your clarification. It's been very enlightening to a layperson. However, I do have just one or two simple questions. Given the new placement of the turbines, can you, in your professional capacity, advise whether there will be any additional water runoff that will affect the lower areas of the Mennock Pass?
I'd like to refer to the site hydrology map at this point, please. Can I get a moment to just look at the map to double check?
inform us which figure you're looking at?
Sure. Yes, I'm looking at FEI figure 7.2.6. Now, there also will be some hydrology figures, but this is the one I have handy. But
a minute, please.
Sure. I think we may be able to get a better drawing from Mr. Innes, who's just looking for a hydrology. Maybe we could get the hydrology drawing instead. Okay, change of plan. We have figure 7.2.3. That's the FEI figure for hydrology, 7.2.3.
It's at the back. This is for the foot at the back.
May I just check that everyone has access to that document? Yes. So, Mrs. Gibb, can I just clarify, you asked about the Mennock water and whether we would have any development within that catchment. Was that the question? Can I check?
No, the question was actually that any of the development that's in the high ridges, obviously water flows down, and my question was to ascertain whether any of that water that would be flowing down from the high ridges due to the development would actually come down and enter the Mennock water.
Yes. With reference to FEI figure 7.2.3, you will see that the turbine array from turbines 7, 8, 9 on Willow Grain Hill lie on the catchment boundary with the Glendine Burn. The Glendine Burn is a tributary of the Mennock water. So there is some development within that catchment area. But as you can see, the particular turbines 7, 8 and 9 straddle the catchment boundary, as you would expect, on the top of the ridge at that area. So they lie between the Glendine Burn and the catchment immediately to the north, which is I'm just checking, I think we've got that classified as the Cogburn. Yes, Cogburn.
Thank you, Mr. Bowen. I appreciate your frankness and your knowledge in directing us to the correct area. You must appreciate that I'm a real novice at this and I cannot read that map. But you've clarified one or two things, which leads me to my next question. Are you aware that the Mennock Path has been flooded regularly over the winters for many years now?
We're aware that there is flooding local to a number of channels downstream of the development. One of the key design criteria that has been part of the assessment process is the application of sustainable drainage systems These are standard practices for developments such as wind farms, road schemes, other urban developments as well. And one of the key principles of these are flow attenuation. So they purposefully are designed for infrastructure such as turbines, such as access tracks and other hard standings, to minimise the runoff rate from the development into downstream channels. And this acts as a lag in terms of time. So the flow period, the peak flow discharge would be expected to come through the Mennick water before the discharge would come out of the site boundary. So these factors have been taken into account, and SEPA would expect us to have such designs agreed, and that would be part of the design, the drainage design that they will have to agree as part of the construction site licence, in due course.
Can you just confirm, sorry for this, but I'm just trying to get an understanding of this. You have you've detailed very clearly that you put in drainage, but if any of this ancillary work, does any of it actually affect the Mennick water in as much as there will be additional works on the Mennick water to alleviate flooding?
No, the additional works we're talking about would be at the locations of infrastructure. So it would be on, as you mentioned, the high ridge, I think it's Willow Green Hill. The works would be conducted up there, and the principle would be that we deal with the drainage at source, as in where the water is falling and being collected around the infrastructure, to prevent that issue carrying on downstream to the actual Mennick water channel itself. So we would deal with it locally rather than more remotely.
Again, excuse my ignorance, but dealing with at source, does that mean that you're going to channel any additional runoff away from the Mennick water?
No, the principles of sustainable drainage systems are that you manage it within the catchment where it occurs, and then you minimise any increase in flows downstream. You also, in addition, treat the water to maintain water quality downstream as well. And there could be other benefits such as habitat creation if we are creating ponds, etc., which will be decided at the detailed design stage.
I think really, I think that's the end of my questioning. Thank you.
Thank you, Ms. Gibb. That was in terms of flooding. Is there any, sorry, Mr. Godfrey, you have a few questions as well?
Not in respect of flooding, but I do have a couple of questions I would like to ask about other elements of Mr. Bone's evidence. Mr. Bone, in paragraph 14 of your evidence, you indicate that additional samples, both soil and water, are likely to be taken at some point in the future to a sort of a agreed format with SEPA. What would actually happen if some of those samples showed elevated levels of heavy metals, given that, I mean, consent would, in that case, would have already been given?
Thank you for the question. Yes, we have already conducted a number of soil and surface water quality samples, which have been analysed and reported in Appendix 7.4, if I remember correctly. The intention is that we will carry out a number of additional samples to get a better understanding of seasonal changes, including for heavy metal content. We would also anticipate sampling a number of extra channels. We previously sampled at 5 locations, I'd anticipate sampling at a number of additional locations. These may be tied in with previous research done by the Coal Authority and SEPA in the local area to build up a longer-term data set. And data from that will then be discussed with SEPA to look at what we are finding pre-construction in terms of heavy metal content, and therefore that will help us to inform our drainage design and our earthwork management, etc., along with SEPA to meet, depending on threshold levels they determine where we need to do extra work. But all works will be done to good practice principles.
Sorry, Mr. Bone. That was insightful, but the question is really what happens after the event if you find heavy metals in the sampling?
If that we have found some evidence of heavy metals in the samples taken to date, as I think most parties are aware, the reason for doing additional sampling is to find more resolution to that data, to find whether that such levels of heavy metal deviate seasonally. And if we were to conduct more samples, we'll have a better idea of that. We may be able to find that there are particular channels which, as you would expect, may have further elevated levels than others and may need to be dealt with differently to the other channels. And what we have found in the data to date has been that by far the location with the highest content of heavy metal has been the channel of the Walnut Water immediately downstream of the historic mining works. We would provide such evidence to SEPA and discuss with them a strategy for managing the situation.
Right, thank you. I do have a question relating to the Water Framework Directive. I think you referred to that in the design, approval and compliance section of your evidence. And I wonder if you could tell me the water quality assessment, it's a national assessment, isn't it? Or international even?
Yes. The Water Framework Directive is a European process which has been ratified into UK legislation and in Scotland is administered by SEPA, who characterise watercourses above a certain threshold size and expect that all watercourses should achieve a good overall standard in the future. Not all watercourses in Scotland have that standard to date.
Are the tests associated with that standard, are they a standard set of tests across Europe?
I can't comment across Europe, but certainly SEPA would treat all Scottish watercourses with the same level, yes. If I may say, I imagine they're similar across Europe, but possibly not identical.
Right. Within that assessment, do SEPA carry out an assessment of contaminants, and if so, what contaminants do they look for?
SEPA have a list of priority pollutants that they will assess for. I do not think they assess every channel for those same priority pollutants. I think they do it on a case-by-case basis.
Right. I mean, it was my understanding that within Scotland as a whole, they normally look for phosphates and nitrates because they relate to the farming situation throughout the country. Do they actually look for heavy metals then as part of that testing process?
I think if they have a due cause or a cause to check, they would do, but I don't think it's undertaken as a default. I must say that I should refer to SEPA's own guidance on this. It's not part of our work to determine that.
Okay, thank you. I've got no further questions.
Thank you, Mr. Godfrey and Ms. Gibb. Right, I have a few questions for you, Mr. Bone, arising from your evidence, but also from what you've just said this morning. Just give me 1 second. Okay, thank you. Sorry, just so I can take a note of these questions. Right, you said at paragraph 8 of your recognition there'd be no risk of flooding as the outflow is downstream of One Lock Head. Now, when we were on the accompanied site visit, we saw that the One Lock Head water is channeled with a concrete channel and a form of a culvert. I just wondered, is there any risk of a backup in a flood situation? So I realise the outflow is beyond the settlement, but you understand the question. Thanks.
Yeah, if I can just clarify, I think that's paragraph 9 that we discussed, the surface water flows. I realise that the One Lock water is canalised at the location you're discussing, close to the mine workings. Once again, to refer back to the principles of sustainable drainage systems, these would aim to attenuate flow at the source of the infrastructure, be that access tracks, turbines, other hard-standing foundations, to minimise any increase in flow to the downstream channel, which would be the tributaries that currently flow into the One Lock water downstream. So we will be putting in place good practice measures in agreement, well, with approval from SEPA, that these are sufficiently designed to be approved for construction site licence in due course. And SEPA are the relevant body for assessing flood risk in the local area and Scotland as a whole.
Now, I'm jumping around the issues here, but in terms of, you explained that none of the infrastructure will be placed where there were potential sources of heavy metal contaminants.
Yes.
There is maybe where there's a condition proposed for micrositing of the turbines and infrastructure. Is there any risk that the turbines or infrastructure might be sited in an area of contamination?
The purpose of micrositing is to, as further ground investigation and other information is gathered at the detailed design stage, micrositing will enable slight, small movements of turbines, etc., where we feel there is an improved environment, no adverse environmental effect in comparison to what was assessed in the first place. Part of those ground investigations would be to look out for any evidence of contamination which has not been identified to date and has not been identified on previous research or mapped sources. So that information would be taken account of, and the micrositing would therefore avoid entering such areas should they be discovered.
You mentioned that one form of SUDS would be to place ponds as a potential. I'm just wondering, in relation to this site, ponds on high ridges or throughout the site, they might be an uncharacteristic feature of the southern uplands. Is that actually a design feature you might follow here? Is there something else?
Yes, the ponds are one option. There are a number of sustainable drainage system techniques that could be adopted. Those will depend on local ground conditions, local topography, and other, as you say, ponds may not be the ideal option at all locations. We'll have to also bear in mind that if they have to if we discuss with SEPA higher levels of heavy metals, it may be that a pond system is the most appropriate treatment strategy. So at which point there will have to be some discussions around that subject matter. So ponds are a potential solution, but not the only solution. Other techniques that could be applied are more linear features, such as grassed surface water channels or swales, which are typically used on other developments as well.
Now, could you give me a comment on the provisions, and I'm not sure if you're aware of this, but Section 78F of the Control of Pollution Act, which is cited by Ms. Gibb, and that's paragraph 5.2 of her recognition. That's in relation to the obligation of landowners in contamination. I wonder if you can make a comment on that.
Sorry, sir, what was the paragraph reference?
It's paragraph 5.2 of Ms. Gibb's recognition, and it's to do with the Control of Pollution Act 1990, and it refers to Section 70F of the Act, citing the appropriate person, the owners of the land, presumably Buccleuch Estates, could be held responsible for the remediation of the contamination arising from historical mining operations. And I just want a commentary on that particular section and what it requires if the witness knows.
We feel that this section is with reference to the historic mine workings and is not relevant to the NLEI development. I would suggest that it's not appropriate for myself to comment on that.
Yeah, I'm simply asking this question more for the information of the ministers, because obviously they'll have this information before them. I presume they can look at the Act, but it would be informative for me to tell them what that section requires. We don't have that Act before us, so if you don't know, it's fine for you to say.
No, it is not part of my expertise to discuss that Act.
So if it would be helpful, and I suspect it would be, I can endeavour to cover that in the closing submission. It is a matter of law in any event, I think, so maybe it should be in that.
That would be helpful, thank you. Now, finally, Mr. Bowen, you'll have noted that Ms. Gibb suggests the landowner pay for remediation in the area. You weren't here yesterday when we discussed the socioeconomic impacts, but would the community benefit package also allow remediation if sought?
I think so. That might be a matter for Mr. Bell, who's dealing with the community benefit package. If Mr. Bowen knows, he may be able to help, but I strongly suspect he does not know about that at all.
I agree with Mr. Steele. Thank you.
Right, Mr. Steele, if you'd like to take your witness for re-examination.
Thank you, sir. Mr. Bowen, there's only a couple of matters, actually. In relation to Section 78F of the Act, you've heard that I'll deal with the legal issues in closing submission. But as a matter of fact, do the areas suggested for remediation or decontamination, do they fall within our, by which I mean the NLEI site and red line boundary?
No, they do not. The design purposely avoided such areas.
So whatever may or may not be the case in relation to these areas have got nothing to do with the development. Is that correct?
That is correct.
Whatever the law says, which I'll deal with subsequently. Going back to Mr. Godfrey's question, if subsequent sampling finds higher levels of whatever heavy metals or whatever else it is the regulator at that stage SEPA or not?
Yes, they are.
So that if you find high levels, are you required to discuss and report them to SEPA?
We would have open reporting and discussions with SEPA with the aim to measure local conditions and therefore manage them appropriately.
And in short, is it for the regulator, SEPA, to determine what may or may not be appropriate in light of whatever the findings are at the relevant time?
Yes, we would suggest treatment techniques and expect SEPA's feedback on those, and they will provide approval or not.
Now, questions about micrositing. I can't remember the precise distance at the moment in the condition, and we'll maybe deal with that tomorrow, but whatever it is the principle that the micrositing would allow you to improve the environmental situation or make the environmental situation worse?
Yes, you're correct.
Which is it?
The former. The micrositing, the principle of micrositing is to improve the environmental situation as more information becomes available.
So is the prospect that rather than moving towards an environmental difficulty, you'd been able to move away from it if something turned up unforeseen?
Yes.
Now, in relation to the sustainable drainage, who decides what the sustainable drainage system will be?
SEPA will approve, we will provide suggested drainage techniques to SEPA. When I say we, the NLEI developer will submit documents to SEPA, who will then approve or ask for improvement.
And are there a number of techniques available to create sustainable drainage, or only one?
There are a number of techniques. It's almost a toolkit, and you can select the most appropriate one for the site conditions and requirements.
And if it was thought, for reasons of landscape or whatever, that ponds were not appropriate, are there other methods that could be used that are equally effective from the point of view of the attenuation and sustainable drainage?
Yes, we could look through the toolkit and identify alternative options.
And I think a couple you mentioned were grass surface water channels or swales.
That's correct.
So if it's thought inappropriate, is there any reason that one would actually have to use ponds if they're thought unsuitable for landscape or other reasons?
No, we could look at other options.
Fine, thank you. No further questions. Thank you, Mr. Bone.
All right, thank you for your time, Mr. Bone. We'll just take 5 minutes while we swap over for Ms. Gibb. Thank you, Ms. Gibb. Are you happy to read your recognition through?
I plan to only read part of my recognition statement. However, by way of introduction, I've got a pre-prepared statement for you. It may save a lot of time in the end. Through cross-examination, I just want to make a few things clear that we are aware of. Is that in order?
If it relates to flooding and contamination for this session, that's right?
Yes, it does.
Okay, well, I'll suggest that you proceed, and if there is an issue,
you can stop me.
You. Yes.
Thank you. Thank you. Right. Whilst we appreciate that there has been a lot of mitigation going on with the preparation of this development, I am here not only as a representative of the Village Council, but also as a member of the community itself. And my concerns don't just relate to the village of Wanlock Head, but to the accessibility to the village of Wanlock Head. And I feel that, given Mr. Bone's comments and statements, there still lies the possibility that there could be additional water flowing into the Mennock Valley and Mennock Water. And we have significant problems as it is without any perceived or otherwise additional waters flowing into the valley. I should have started by saying my name is Isabel Gibb, and I'm a member of Wanlock Head Village Council. I'm also chair of the Wanlock Head Community Centre SCIO. As a member of the Wanlockhead Village Council, I've been actively involved in the opposition of this application, both in its original format and its now reduced format. As a member of the Village Council, we were keen to ensure that we were representative of the residents, and these were consulted on and balloted on with regards to the original development, bearing in mind that there has been an awful lot of changes, and we appreciate some of the developers' changes, but not all of them. Unlike Sanquhar Community Council, although elected representatives of their community, they did not ballot their community. My speciality, as it were, bearing in mind that I have little or no educational interest or knowledge of any of this up until 4.5 years ago, it's been quite an eye-opener to see just how things work, how the development process and its mitigation on certain areas work. I fully appreciate that a lot of the information, both in our inquiry report and my precognition statement, is actually moot at this point. But with regards to the flooding and contamination, I still have several concerns. I'm going to read you now certain areas of precognition statement. I would refer you first to paragraph 3, item 3, contamination, our original case, and take you down to the sentence that begins during the 18th and 19th and early 20th centuries. During the 18th, 19th and early 20th centuries, significant amounts of lead were liberated into the atmosphere through the inefficient smelting of the lead ores using the technologies that were existed at the time. The gases from the smelting process contained lead. As these condensed, this resulted in fallout of lead and other heavy metal particles within the surrounding area, the dispersal of which was dependent on particle size, wind strength and direction. I would like to put on record that up in Wanlockhead, in the high reaches, we have had winds in excess of 100 miles per hour. These are sometimes northerly winds, southerly winds, or really sometimes you can't tell which direction they're coming from. I'd like then to go on to 3.5. The impact of heavy metal contaminants in soil and local ecosystems is well documented in my inquiry report, and I quoted from Chapter 7C of the Scottish Government's report in 2006 entitled Scotland's Soil Resource. It currently states the threats. It highlighted the enhanced levels of heavy metal contaminants within the mining area, but that high levels, particularly of lead, are also observed in soils from higher ground around the local smelters. It went on to describe local impacts on the, I'm not going to say this right, biotic environment, including lead poisoning to fish and skeletal disorders in lambs grazing on contaminated pastures. It should be noted that although the report principally related to the contamination at Glengonner water close to Lead Hills, it notes that contamination levels at certain points along the valley of the Wanlock water are significantly higher than those within the Glengonner Valley. It is therefore safe to assume that the comments relating to soil in the vicinity of Glengonner water and directly transferable to the soil in the vicinity of the upper reaches of the Wanlockhead water, in the vicinity of Wanlockhead and around the Buccleuch smelter. What is omitted from that is that we didn't just have one smelter, we had two smelters, the Queensbury smelter. Jump forward and take you on to 3.8. As part of the environment assessment, the applicants arranged for soil samples to be taken both within and outside the former mining areas. And I would like to interject and note that in Mr. Bone's evidence, he said that five soil samples were taken. I would ideally at this point like to know exactly where, but I believe that the majority would be around the water basin of the landlocked water. This included soil samples taken from various points along the routes of the proposed service tracks. The analysis of these soil samples, and I'm agreeing with Mr. Bone at this time, showed elevated levels of chromium and nickel. More than half of the samples taken outside the former ore field, similarly water samples taken within the catchment below the proposed wind farm development, all showed elevated levels of chromium. And at two of the upper sites, elevated levels of copper. The Michel report suggested that heavy metal pollution outside the former mining areas is likely to originate from the underlying bedrock materials, i.e. the natural bedrock of the area. In its conclusion, the report stated that the natural ground contains elevated heavy metal concentration, which provides a potential source of heavy metals to the water environment. I'm coming close to the end of what I wish to read in my recognition statement. Moving on to 4.2. By substantially altering the boundary of the application site and deleting turbines 10 to 14 and their associated infrastructure, the applicants have removed the threat of increased mobilisation of the potential heavy metal contaminants through disturbance within the area of the site, which has been designated as medium risk to the mining assessment carried out by Michel. I'd like to interject here and just state that Dr. Van Drieken and all the previous applicants, witnesses, especially Dr. Van Drieken, because he's been in it from the start, actually suggested to his developers that these turbines should not be included. And it was on the developers' insistence that these were included. It's interesting to note that this was only because they would be seen from the village of Wanlockhead, rather than to note that there's actually a mine within short distance and ground contamination within that area. To continue, Wanlockhead Village Council and Lead Hills Community Council wish to maintain our rejection to the proposed development on the basis that groundworks required to implement the development is likely to mobilise heavy metals within the soil within the development site, even outside the former mining area identified by Michel as medium risk. The leachability tests conducted by Michel relating to sample sites outside the former ore field reveal that copper, zinc and cardamom exceed SEPA's environment quality standards at various sample sites. Sorry. It is our contention that, given the considerable volumes of materials which will inevitably be disturbed by the proposed development, there is thus the potential to release elevated levels of contaminants into the environment. However, in conclusion, Michel considers that by implementing good practice for material handling on site, the drainage design and avoidance of significant mobilisation of heavy metals from natural materials is considered manageable. Under the Water Framework Directive, there is a requirement to bring water bodies to good or good potential status. The Coal Authority report entitled Landlocked Benefit Assessment Explanatory Note, the report argues that dissolved cadmium levels have the effect of reducing the status of Croik water, Spangle water, to a moderate status. It is our argument with the engineering works required for the proposed development will mobilise soluble forms of heavy metal, particularly cadmium, which will be likely to raise contaminated levels in the Croik water downstream of the development. We argue that the proposed development will frustrate the WFD requirement to work towards improved water quality. So in conclusion, whilst I appreciate that there has been a lot of mitigation work done, I still have several concerns in relation to flooding and contamination, and I welcome any cross-examination on that basis.
Thank you, Ms. Gibb. Mr. Godfrey, are you seeking any clarification from the witness?
I just have one minor point to clarify. I mean, obviously, contamination and possible health effects are a considerable concern to yourself, but is it true to say that those concerns are held by other people within the community?
Yes, it's very true to say that these are held by other people within the community. In particular, that gives rise to the 2016 report under the Freedom of Information Act, and not just to the report itself, but to one of the comments that was made within the emails that flew back and forwards between the Environment Minister, the Coal Authority and SEPA.
Thank you. Mr. Edwards, Mrs. Richford, I think, has one or two other questions that she would like to ask on behalf of the Wanlock Head residents.
Well, sir, I'm not quite clear what's going on here, to be honest. Presumably this is a witness on the same side, and I'm just... Well, Mrs. Gibbs shaking her head, but perhaps we could have clarification. This isn't obviously an opportunity for other members on the same side to elicit more evidence.
No, I mean, Ms. Richford's been introduced to the inquiry last week, certainly on the same, I think you're with Wanlock Head Village Council, and certainly what I'm not looking for here is for you to provide further support or evidence. You can ask points of clarification of the witness before they're cross-examined on the matters of flooding and contamination, as Mr. Godfrey has.
May I just have a minute or two to go through those questions to see if they are eliciting more evidence or whether they really are clarification, and I think that would hopefully satisfy yourself.
Thank you.
Thank you for that, Mr. Godfrey. Thank you, sir. Ms. Gibb, firstly, do I understand that you're appearing here on behalf of Wanlock Head?
Yes, I'm appearing here on behalf of Wanlock Head Village Council and the villagers of Wanlock Head. And
so far as Lead Hills are concerned, this issue is really not relevant to them. They may have an academic interest, but there's no real interest because of topography and geography.
That is correct.
Thank you. Secondly, on reading your evidence, is it apparent that many, perhaps not all your concerns, but many of your concerns have been addressed by the mitigation within the revised application, as you call it, at Chapter 4?
That is correct. However, within the mitigation itself, I still have questions.
And do you realise, as I'm sure you do, that SEPA are the relevant regulator in relation to these matters and have raised no objection to the proposals? Do you realise that?
Yes, I'm well aware that SEPA have no objections and that they are the relevant body and relevant to this proposal.
And do you also recognise that SEPA will have a continuing interest as the regulator to authorise or otherwise works at various stages, including the plans and the works and the like? They are the relevant regulator appointed by government.
Fully appreciate that they are the relevant regulator appointed by government.
And does that not, Ms Gibb, give you sufficient comfort to be certain that matters will be handled properly, because the regulator SEPA will be overseeing them and, by definition, regulating them throughout?
To a certain extent, yes, it does give me a matter of comfort. However, given the 2016 report, which I realise is now almost entirely mute because of the change, the pushback of turbines, etc., it gives me comfort that they are appointed, but it doesn't give me comfort that they will actually follow through on anything that they find, given the fact that they have found a variety. Sorry, I'm going off piste here. So, given the fact that the 2016 report turned up a number of issues, we are now in 2019. None of these issues have been mitigated, taken care of. It is their responsibility to do so, along with the landowner. So, really asking me if I have faith in SEPA? Probably not as a person. And I can further, I can tell you what drives this, and my opinion is that when I first asked for the report under a Freedom of Information Act, I went to the Coal Authority, being the authority that I thought would have dealt with this, and the actual people who actually did the report, and they told me that they had nothing to do with it. They didn't have anything to do with mines, and they had nothing to do with the 2016 report. I then wrote to SEPA. I was told I would get the report within X amount of days, on a specific date. When that date came and went, 2 months later, I thought I'd given them long enough. I chased them up. Still no answer. Still no copy of the report. Nothing. Under the Freedom of Information Act, that should have come straight away. It took Mr. Mundell, Junior and Senior, to intervene on my behalf. And lo and behold, the report was sent. My concern doesn't lie with the report itself, but lies with comments that were in the documentation that followed that report. Those being in one particular email, it quite clearly said, if this is common knowledge, I'm surprised there is not an uproar with the production of this report.
Well, Ms Gibb, do you see matters from our point of view, which is this, that we have mitigated matters to the best of our ability, and we accept and expect that we will be regulated by SEPA to ensure that there are no difficulties, but you don't accept that SEPA, as the regulator, will do their job properly. Do you see the difficulty that places us in?
I fully see the difficulty that places yourselves in, but given that you have already employed someone who is very knowledgeable in the development of this, I would suspect that Mr. Bone will also be at some stage retained to oversee or ensure that everything is in accordance with SEPA's requirements.
Well, of course he will. And do I take it from that then that you would have confidence in Mr. Bone to oversee matters to ensure that everything is done as it should be?
I personally have more confidence in Mr. Bone than I do in SEPA.
Well, that's a good vote of confidence for Mr. Bone, I think. But Ms Gibb, can we not agree this, that between the two of them, that is SEPA and Mr. Bone and his firm, that must give sufficient comfort to you and the local residents that have raised these issues. Would that not be fair?
That would be correct insofar as the water situation goes, with the exception of the fact that the Mennock floods regularly. We have got a long way around to go with, and I appreciate Mr. Bowen has stated that there are several methods that can be used to reduce the levels of water flowing into the Mennock. Because I'm not an expert, don't know how they can turn on and turn off water, and if they can they please make sure that it flows during the summer months when the Mennock is relatively dry, and not the autumn and winter months where we have flooding potential, and not just potential, where it actually has flooded.
So, in short, I'm not sure that you can guarantee that it won't rain at certain stages, Mrs. Gibb, but are you reasonably comfortable if Mr. Bowen and his firm are involved, overseen by SEPA? Is that not really a pretty satisfactory position for the residents to find themselves in?
It offers me more comfort that there is another company involved as well as SEPA in this. However, that only relates to the flooding and does not relate to the contamination.
Fine, thank you, Ms. Gibb. I've got no further questions. Thanks, sir.
Okay, thank you, Ms. Gibb. I just have a few questions for you. Firstly, at paragraph 3.6 of your recognition, yeah, you say there, the second and third line down, well, starting from being documents such as those referred to above fuel the concerns of the local communities and make us defensive when threatened with proposals which we perceive as having a potential negative impact on health. Now, I wonder, does that mean people are fearful of what may occur despite reassurances from the applicant and no objection from SEPA and the council? Just the kids in the background are a bit of a distraction. Sorry, would you like to repeat your question? Yes, in essence, I'm wondering if the issue here is a perception, a fear of something happening rather than an actuality of it happening.
I think it's probably a bit of both. Fear of the unknown is very difficult to quantify. Given the letters from the health service that we've had out stating not to use the water, not to go in the water for any length of time, not to grow vegetables in your soil or subsoil, irrespective of where you stay in Wanlock Head. It's already a concern, but it's also a concern that there may be further implications. In particular, we've got a lot of contamination on the ground, all of which was caused by the landowner or his subsequent lessees. I am conscious that the landowner does not recognise that he was responsible for the existing contamination. But it goes further than the existing contamination. It looks at, the villagers look at the land as a whole, and lead contamination is one thing, but concrete contamination is another. 30 turbines is a lot of concrete. 30 turbines with, I noted Mr. Bowen actually mentioned the micrositing. Now, 30 turbines with a microsighting of 100 metres for each turbine could, in effect, and not necessarily, mean that, God forbid, that every turbine you check the soil and you have to move it. There's already been soil disturbance in that area, and then you're going to move it to another area. It just beggars belief the amount of contamination that's going to be in. And in my view, concrete is contamination where concrete's contamination. And when the plans to remove the contamination, I have noted on the conditions that these don't actually kick in until 3 years towards the end of the lifespan. Now, given the problems that we've had and that Scotland has had in the past with coal mining and trying to get restitution and to clear up the coal mining, and I'm appreciative that the Duke of Buccleuch actually did this with Croix Multiverse. I fail to understand what the difference between clearing up the coal mine at Croix Multiverse, although it was an eyesore. They couldn't clear up the contaminated areas within One Lockhead. I think I've probably said enough.
No, thank you, Ms. Gibb. You've confirmed my question. We'll talk about decommissioning and aftercare potentially on Wednesday in the conditions session. So that point you can raise again. In terms of paragraph 4.3 of your recognition, you suggest that groundworks are likely to mobilise heavy metals. But then at the end of the paragraph, you appear to accept that good practice would avoid mobilisation. So just to confirm, are you in agreement that any risk could be mitigated?
In as much as they possibly can be, given the topography of the hills and the nature of the former lead mining in the hills, and in as much as it possibly can be.
Now, I realise this is going to be a question for Mr. Bell, but I'd like to ask it of you. You suggest at the end of your recognition the landowner should pay for remediation in the area, and I think it's something around £2.5 million. Could the community benefit package, which we heard yesterday might equate to £18.6 million, could that be used to remediate the area?
It possibly could be if we were getting 18.6 million as one lump sum, instead of getting 730 odd thousand per annum. You can't, it would take a number, it would take probably the lifespan of the wind farm to actually fully remediate the area, given the small sums that we had to work on. It would be very difficult to work a project up to ensure that that money is actually cleared the whole area within the lifespan of the...
Okay, thank you. I have no further questions. In terms of re-examination, Mr. Godfrey, Ms. Richford, and remember, it would have to relate to any questions in cross-examination.
Yes, Mrs. Richford has just indicated that she has a point of clarification that she's looking for.
Mrs. Gibb, may I ask a question? Well, I want to clarify the details that you've given about the benefit and its totality. It's not going to come to One Lockhead. It's going to be shared with other communities.
That is correct. And taking aside that there is currently a proposed land buyout happening in One Lockhead at the moment, if you put that aside, if that weren't to go ahead, the community benefits would actually come to the village and circulate back to the Duke himself because we would be asking him for money, well, we would be asking the developers for money to clear up the mess left by who I understand, who I believe is changing, the developers themselves. So you're giving them one hand, and you're giving it back to the developers in the other. Without the proposed buyout, surely, if you take that out of the equation,
Earlier, we're about to have a session on ecology and ornithology with 2 witnesses. Because we might be describing the location or presence of protected species, we've agreed that this session indeed, and the 2 witnesses will not be filmed. So for that reason, we're going to stop the filming as of now. Cultural and Built Heritage Inquiry Session. There are 3 documents that have been placed on my desk. They seem to be the Spangler decision and a map showing the SPA in the context of the Spangle Bridge wind farm. Can I confirm, one, that these are accepted, and if they are, what document number we should give them?
They're my documents. I think both parties reached the conclusion. You remember this was referred to last week, and I said Mr. Robinson was going to deal with. First point is just a matter of substance. The decision letter actually incorporates the report within it, so we can reduce the documents down to 2. So just the decision, which has actually the report attached to it, and the plan, which shows you the location. And also, we felt it was useful because it may or may not assist Mr. Steele in showing the extent of the SPA within one of the areas, the area to the north of the LCA, which the site's in. So they're likely to be CD numbers, and my glamorous assistant is going to tell me what they should be. 753 for the decision and 754 for the maps. And I understand there's no dispute about them coming in. I'm sorry they're so late, but it should save time later on because Mr. Robinson can simply refer to them.
So, sir, just to confirm, 753 is the letter dated, or decision dated 24th of September. The second document I've got is being dispensed with, and the plan is 754.
Actually, the second document.
Right, Mr. Steele, if you'd like to take your witness in Cultural and Built Heritage. Thank you.
Thank you, sir. In all the circumstances, I intend to take this witness very briefly indeed, sir. Mr. Moody, copies of your inquiry report have been circulated, and apologies from us, sir, there's no actual precognition as such. It somehow slipped through the net. We thought there wasn't going to be a session, then there was. Anyway, Mr. Moody, could you go straight to paragraph 4 of this document and read that?
Good afternoon, everyone. I've been engaged in the NLEI project since the outset and consulted with both Historic Environment Scotland and Dumfries and Galloway Council Archaeology Service to agree the scope of works required for the EIA and the choice of representative visualisations to be provided to inform the Cultural Heritage Assessment. I am the author of the Cultural Heritage Assessment presented in the Environmental Statement 2017 and the Further Environmental Information Report 2018.
Paragraph 5, part of that, please.
The sensitivities of the historic mining remains at One Lock Head and at Lead Hills were identified early on in during the project and highlighted to the design team. It was therefore determined that early and constructive engagement with the consultees, in particular Historic Environment Scotland, would be an important aspect of the application. Subsequent to the, moving on to paragraph 11, subsequent to the site meeting, the comments and potential issues noted by Historic Environment Scotland were relayed to the design team. It was my advice that, although HES had not raised any objections in relation to any particular turbine locations, we should nevertheless seek to adjust the layout, where possible, to further reduce the visible impact from within the scheduled monument and conservation area at One Lock Head. That advice, combined with advice from other environmental considerations, led directly to revision of the proposed development as the design evolved. Of particular relevance to the designated cultural heritage assets, the changes that have been adopted include removal of the option for a southern access through Lead Hills and Wanlock Head, removal of the option for siting the substation within the Wanlock Valley, close to the former Patesnow lead smelter, deletion of a wind turbine on Snarehead Hill to the north of the Patesnow lead smelter, relocation of turbines on Glengabber Hill and above Dunter Clew to the west of Wanlock Head, and finally deletion of turbines T10, T14 at the FEI stage to remove visibility from the Mennock Pass and from above the Auchengrooth Craig cross-shaped earthwork scheduled monument. The instituted changes resulted in a reduction of the visibility of the proposed development from within the Wanlock Head scheduled monument and conservation area, and at the FEI stage, the elimination of a significant adverse effect on the setting of the Auchengrooth Craig cross-shaped earthwork.
Now, I think you're aware, Mr Moody, that Mr Mundell, the MSP, suggested yesterday that we had simply ignored any comments or concerns that has been raised. From your professional point of view, is that accurate or inaccurate, true or false?
That would be inaccurate. We fully took on board the advice that came back from Historic Environment Scotland during the course of the site visit. We visited all of the proposed viewpoints along the Wanlock Head Valley, and we added, at the request of Historic Environment Scotland, an additional viewpoint to that so that they could appreciate the view from the Glencreef mine.
Can I then ask you to turn, please, to the concluding remarks at page number 17 of this document and read from paragraph 83.
Thank you. I have laid out above the process by which consideration of the cultural heritage has informed the design of the proposed development. Preservation of the cultural significance of the industrial mining remains, and the character of the two mining village conservation areas has been achieved through a process of consultation and design changes that have resulted in minimising the visibility of the proposed development from the designated heritage assets at both Wanlock Head and Lead Hills. It has been shown that both Historic Environment Scotland and Dumfries and Galloway Council Archaeology Service are satisfied that the assessment was properly conducted and that the methodology applied was appropriate. Both parties are also in agreement with the findings reported in the environmental statement, and neither has raised any objection to the conclusions drawn. There are no grounds in any of the responses received that lead me to believe that the assessment of the impact of the proposed development is in any way deficient or inadequate. I stand by the assessment in the environmental statement that the impact on the setting and cultural significance of the historic mining remains at Wanlock Head and those at Lead Hills will be of low magnitude and minor significance and not significant in EIA terms. I am fully satisfied that in both cases, Wanlock Head and Lead Hills, the cultural significance of the industrial heritage will be preserved and that it will remain possible for any visitor to fully understand, appreciate and experience the industrial heritage, and that the sense of place derived from this industrial heritage will be undiminished by the proposed development. I am therefore firmly of the view that the proposed development does not conflict with the statutory tests, neither does it conflict with the policy tests set out in Scottish Planning Policy or with Historic Environment Planning Statement 2019.
Now, finally, Mr Moody, in relation to the attitude of the Council to this matter, could I ask you to look, and I'll just pass it to you unless you have it to hand. Firstly, document CD 2.36. Do you have that in your... No, that's the internal memo from the Council. And that's to the original application, I think, if I've got it round the right way.
I have that in front of me now. Yeah.
And was there any objection to the proposal at that stage?
There was not.
having regard to cultural heritage issues.
There was not.
We then made the changes which you've outlined, and there was a further consultation response, CD 3.35.
I don't have a copy of that.
Well, let me pass you this. Thank you. And does that confirm, again, perhaps rather obviously, that there were no objections, and did that letter welcome the further mitigation that had taken place? I can't remember the precise wording. You have my document.
Sorry, the document I have in front of me now says that the proposed reduction in turbines will remove any historic environment on Auchengrooth Cross and further reduce indirect impacts on features around Stake Hill and One Lock Head. Which
Does it appear in
slightly
brief?
odd statement, I'll grant you.
Does it appear in
But
brief?
there is no objection.
And in brief, you and the cultural heritage expert within D&G Council are at one. Is that so?
That's correct.
Sorry, Mr. Steele, thank you. You have no further questions? Okay. Mr. Godfrey, do you have any questions in cross-examination?
Yes, I do. Mr. Moody, I note that in your Appendix 1, you provide a plan showing basically the main scheduled area, the Lead Hills area of mining and smelting remains, together with a plan. There's a blue line which shows the boundary of the conservation area. Now, are those remains extensive in nature or not?
I think just for the reporter's benefit, you're talking about the Appendix 1 to my inquiry report,
to your
NLEI
inquiry.
9.
Yes, indeed.
Yes, the figure that you're referring to there shows the extent of the scheduled area, which encompasses the majority of the sensitive industrial mining remains. It doesn't obviously encompass all of the mining remains that lie in the wider landscape out with that.
Just how extensive are those remains insofar as over what distance do they continue down the One Lock Valley from the southeast of the scheduled area to the northwest of the scheduled area? Over what distance would you estimate that the remains carry over?
I think in terms of the remains at One Lock Head, I think the scheduled area encompasses all of the main archaeological sites there. There are some additional remains up on Stake Hill, which is to the southeast, but I'm not aware of any that are further to the northwest. I think there may be one or two small additional elements out with that, but not at the same level of intensity as the remains within the scheduled area. If that answers your question.
In terms of the distance from the southeast boundary of the scheduled area in the context of the One Lock Head scheduled monument to the northwest, would it be fair to say that over what distance would those remains actually extend in terms of kilometres?
Very quickly, that looks to be about 3 kilometres from.
Right. So that those remains obviously extend. You would agree that those remains extend a fair way along the Wanlock Valley?
2 to 3 kilometres, as I've said, yes.
Right. Your blue line on that plan, it shows the boundary of the conservation area, does it not?
Yes, that's correct. Just for added emphasis, the purple line is also the archaeologically sensitive area, which outlines the area of the important archaeological remains as defined by Dumfries and Galloway Council Archaeology Service and recognised by the Council.
Right, thank you for that. The boundary of the conservation area is very, very extensive, isn't it?
Sorry, it's quite extensive. Yes, it does. It encompasses the village and extends beyond the village down to beyond Meadowfoot. Yeah. Although it's also rather oddly drawn in as much as it appears to follow the national grid coordinates in straight lines rather than any sort of defined landscape features on the ground that could recognisably be identified by anyone visiting the area. Yeah.
In your experience as a conservation expert, do you often find conservation area boundaries that are so extensive?
It's not entirely unusual. I would suggest that the conservation areas of the centre of Edinburgh, for example, are considerably larger than those here at Wanlock Head.
Yes, but I mean, the conservation areas in Edinburgh, presumably they encompass important gardens as well, do they?
They do indeed, and just the same as here, the conservation area is intended to encompass many of the archaeologically sensitive remains that surround the village and which also provide or contribute to the character of the conservation area. They're effectively part of the conservation area, or the area of cultural significance that's to be protected. Hence, I think, why the boundary, particularly to the northeast, is drawn in as very straight lines.
Yeah. So the width of the boundary, would that indicate to you that the setting of the village is regarded as important, or was regarded as important by the people who drew that boundary?
Certainly, yes, and I can see from looking at this that the boundaries largely respect the kind of topography of the valley and extend upslope from the village and take in the hillsides above that to a degree.
Yeah, that I was going to lead on to that next point. The as you say, I need to phrase this as a question. There has been a recognition, has there not, that the hillsides form an important component of the conservation area?
I think there is a recognition in the way that the conservation area boundary is drawn that is the case, yes.
It's very difficult from your plan Annex 1 to get an indication of the vertical nature of the hillsides in respect of, I say vertical nature, I'm probably not doing myself justice there. There is a verticality, is there not, in the both the scheduled monument in terms of its boundaries and the conservation area in terms of its boundaries?
I agree with you, Mr. Godfrey, that the hillsides there are very steep indeed, and I think that the conservation area boundaries, by and large, and that of the scheduled area, reflect the extent of, shall we say, the lower slopes of those hills. I think you'll find that the boundaries as they're drawn here do not extend up to the summits of that hill range.
Right. Can I refer you to figure 6.14D, which is a photo montage. It's viewpoint, also viewpoint 4. That view. It's viewpoint 4, upper Wanlock Head.
Yeah, we're just looking at it because there's an ES and FEI, so it's in the ES because it wasn't reproduced in the FEI.
Right.
Sorry about that. We have it now. It's in the environmental statement.
Yes, I had trouble finding that particular one as well. But
sorry, which section of that? I've got the front cover at the moment. Which part of it do you want to look?
It's viewpoint 4, upper Wanlock Head. Figure. It's also referred to as figure 6.114D.
B, did you say, or D?
D.
D.
For dog.
I have that now, yes, thank you.
Would you agree that that's an important view in terms of the setting of the village and indeed the positioning of the turbines on the hillside, top of the hillside, or beyond the top of the hillside?
It's one of several views from within Wanlock Head. Yes, it's not. I wouldn't say it's the most important one, but it's certainly one that shows provides a good view of the village and the industrial remains that extend along the village from that, beyond the village from that viewpoint. Yeah.
Now, you said previously that the boundary of the scheduled monument and also the boundary of the conservation area extend up the hillsides. And are you able to make an informed guess, really, from this plan as to just how far up the hillside the boundaries of these two areas would extend?
Looking from this viewpoint and taking what I know of the landscape into consideration, I would suggest that it's approximately a third to halfway up that hill slope.
So it's a significant proportion of the hill that is encompassed within these particular designated areas.
Well, it's a sizable proportion of the hill slope on the lower valley sides, yes, and that's where the main mining activities are taking place. So the boundaries there are drawn in order to protect the full extent of those remains.
Sorry, your microphone, Mr. Godfrey.
Right. In your inquiry report, you indicate that the remains, in your opinion, are of low magnitude and of sort of minor significance. Is that not the case?
I think you mean that I've not said that at all. I said I think the impact on the setting of these industrial remains is of low magnitude and minor significance. But I do not say that the remains themselves are of low significance.
Sorry, I was probably sloppy in my use of words. You were saying that the turbines and their impact on the setting would be of minor significance. Is that the case?
That is the case, but that's not just simply relying on this single viewpoint. I've taken my assessment as looking at the extent of the remains in the round, including reference to a number of visualizations and viewpoints along the valley, from including this one and extending down as far as the Patesnell lead smelter. Yeah.
Sorry, Mr. Godfrey, just your microphone.
Turning now to the scheduling document for the remains of lead mining at One Lock Head. Are you familiar with that document? Or I can give you a reference. It's one that we selected. It's WL8.
That's okay. I have a copy of that. I think I have a copy of those to hand here. Just bear with me.
Okay, sorry, just Mr. Godfrey, for my own purpose, can I now remove viewpoint 4?
Put it to one side, please, for later on. Turning to the statement of national importance at the bottom, the second paragraph down, it lists a number of assets within that scheduled monument, does it not?
It does indeed. It lists a number of components of the remains, but it's also worth noting the first paragraph, which states that the area to be scheduled is of national importance, as it contains most of the significant remains of metal mining and working in one of the most valuable metalliferous areas in Scotland, which is why the boundary is drawn where it is.
Yes, I mean, there are quite a number of assets actually identified there, are there not? In that, could you list those assets that are identified there, please?
There's the Meadowfoot Smelt Mill, the Bay Mine, Glencreef Mine, the Beam Engine, the Beam Engine on the Straight Steps vein, Patesnell lead smelter, and the ore crusher at Meadowfoot.
Now, on the paragraph below, it actually states in this scheduling document that each of those is of national importance, does it not?
It does.
So in scheduling terms, you're almost getting half a dozen scheduled monuments in one scheduling statement. You're getting 6 for the price of one, almost, are you?
I don't think it works quite like that, sir. No, I think what you've got here is you've got a collection of monuments which together are of national importance. I think you'll find that the Beam Engine, which is listed within this group, has its own scheduled entry, which is the other document that you provided yesterday.
Yeah.
So yes, you do get 6 for the price of one.
But But the key point there, is it not, is that each of these particular assets is identified as being of national significance, is it not?
That's what the document says, yes. There's no reason to doubt Historic Environment Scotland's assessment of that fact.
Yeah. Can we move on now to another aspect? You refer to a couple of inquiry. Thank you. You refer to a couple of inquiry decisions in your inquiry report, do you not?
That's correct, yes.
And are you aware of the decision in relation to the Harryburn public inquiry, which the result came out last week, or a couple of weeks ago?
Yeah, I'm aware of it, but I have not actually read that report at this present time, no. I was actually on holiday when the document came out, and I've been rather busy at work on it subsequently, so I've not had an opportunity to review that at all.
Right. Can I ask that a copy is put in front of you, please? It's
CD 7.52.
yeah, CD 7.52. Yeah.
Yes, I've got that now.
Right. Can we turn to paragraph 4.27, and this paragraph relates to the conclusions which the two reporters on this particular inquiry came to in respect of the impact of the Harryburn wind farm on scheduled areas and in respect of the conservation area at Lead Hills.
Sorry to interrupt you, Mr. Godfrey.
Yeah.
If you read up, I think this isn't actually the reporter's findings. This is a summary of the council's case, 4.27.
Oh, right. Yes, indeed.
I mean, sorry to interrupt you, it may still be relevant to your question, but just to put it in context, it's not the reporter's
okay.
finding.
Obviously, it carries less weight than had it been the reporters. But the council indicated that they were not happy with they felt that the assessment carried out by the expert witness for the Harryburn applicant, they felt that their analysis was flawed. Is that not the case?
That's certainly what it says here, but I note that the paragraph actually says that the conclusion in the additional information that these key characteristics would be entirely unaffected by the proposed development or the proposed wind farm is flawed. Yes. This appears to relate to additional information and not to the assessment that was carried out in the environmental statement. And you know, in all honesty, I can't really comment on the evidence that was put before that inquiry that I've not had an opportunity to see, and therefore comment on the validity of that assessment myself.
Yeah, that's fair enough. I was not impugning your professional status there. I was just trying to draw attention to there was actually two expert witnesses at the Harryburn inquiry, and they did their evidence was somewhat conflictual. One said that no, okay.
Sorry, Mr. Godfrey.
Yeah.
We can read that. Do you have a question based on that for the witness?
Yeah. Is it common, in your experience, for professionals in having giving evidence on a cultural and heritage background to form different opinions of the same facts.
It's entirely common, and I think that's borne out by the responses that come in from the consultees, who are themselves professional archaeologists, both for the Council and for Historic Environment Scotland. They may take issue with the assessments that are presented to them in the environmental statements, and two independent experts, as in the Harryburn case here, may come to entirely different conclusions, because basically we're drawing by and large on our own professional judgment, following the methodologies that we commonly use as individual experts. We don't follow. There is no set methodological approach to conducting these assessments, although there are documents out there at the current time. There's documents been released this year that are trying to sort of rectify issues in relation to the diversity, shall we say, of methodological approaches.
Right. Can we sort of move on to the overall conclusion at the Harryburn inquiry? That's obviously at the end of the report, paragraph 916. And there is a series of bullet points there, and the fourth bullet point, one of the reasons that one of the conclusions that was drawn by the reporters was that there would be a moderate impact on the cultural heritage assets, and the conservation area would be very severely affected. That's the case, is it not?
With respect, I don't think that is actually the case. If I can read that bullet point out to you, it actually says significant landscape and visual effects would arise. There would be a moderate impact on 11 cultural heritage assets, and harm would be caused to Lead Hills Conservation Area, all of which cannot be mitigated.
Right. Yes. Okay. I take the point there. Right. That's all the questions I have for you, Mr. Moody, and thank you very much.
You're welcome. Thank you.
I can see that you're looking at me, Ms. Gibbs, so you're welcome to ask questions, but again, you've got to make sure that they're within the remit of Mr. Godfrey's recognition and submissions.
In which case, I have no questions to ask.
Okay, if you're sure, I mean, you could always ask the question. If I have a problem with it, we can tell you, but...
I would appreciate your guidance on that, Mr. Edwards. Really, the first question I would like to ask is in conjunction with the Auchengrove, Crosscraig and Stake Hill. You'd mentioned that by way of mitigation, these were the only two remaining items that fully could not be mitigated out of this construction. Is that correct?
I'm not sure I'm not sure I understand your question exactly. That's not the case at all. The design was modified during the course of the design evolution, following on from the consultation that we had with Historic Environment Scotland on site, where we visited a number of locations within One Loch Head, and all of the key significant elements of that scheduled area, which we just went through with Mr. Godfrey there. And overall, on balance, it was felt that the development was acceptable in cultural heritage terms. The Auchengrove cross-shaped earthwork was a slightly different case. But that was resolved at the FEI stage.
Excuse me if I'm wrong, but did you not make mention also of Stake Hill?
I didn't make any mention of Stake Hill. Mr. Godfrey raised Stake Hill as an issue.
I may well have been confused, and I beg your pardon on that. In that respect, given that Mr. Godfrey raised the issue of Stake Hill, are you aware of the significance of Stakehill and why it's called that?
To be honest, no, I'm not.
I'm not allowed to give a statement or a description of fact, but I would suggest that both the reporter and yourself and Mr. Steele go away and look at the history of Stakehill, and I think you'll find it quite fascinating.
Thank you for the information. I'll endeavour to do so.
Okay, thanks, Ms. Gibb. Just for everyone's clarification here, myself and my colleagues are not allowed to go looking for information. We work in a quasi-judicial environment, so I can only look at the information that's presented or submitted to me. And that's probably part of the reason that you've seen over the last couple of days. I've had to ask parties if they're happy to accept late documents. I won't be going on Google or anywhere else looking for information, just to clarify that for anyone. Now, I have a few questions for you, Mr. Moody. Firstly, do you know if there's a conservation area character appraisal for the One Lochhead conservation area?
I'm not aware of one, no.
And so in its absence, is it for the assessor and decision maker to determine the character and appearance of the area?
That would be the case, yeah.
And so, in your professional opinion, what is the character and appearance of the conservation area?
I think the combination of the village houses and the street layout and its proximity to and connectivity with the industrial remains that surround the village and extend to the northeast of the village, the isolated and intimate, almost secluded setting at the head of the valley with the mining remains extending to the north provide that context, and the buildings themselves, the way they're distributed within the building, provide it with the character. And it's that mix of sort of late 18th century, early 19th century single story, formerly sort of thatched mine workers' dwellings, with the sort of later 19th century larger houses of the mine supervisor, shall we say, and then you've got the sort of the supporting infrastructure that went with that, the institute, the miners' library, and so forth. So it has that kind of, it's that sort of little dispersed village character that gives it its unique qualities, I would suggest. Just to add that it has a very sort of, to my mind, it has a very sort of intimate feel as well, the village itself.
Thank you. Now, I think you've answered this already. I was going to ask if it was a cartographic error, but that is the true reflection of the conservation area boundary, to your understanding.
It is, yes, surprising though it is. I confess that I did find that unusual myself, but you'll see when you actually look at it that you can see just to the just below that's the right angle. There are two valleys, one that extends to the northeast and one little one that extends to the southwest, which is where the Glen Creef mine is located. Those sort of little valleys there are included within the conservation area, and then someone effectively has just simply drawn straight lines that follow the grid coordinates to connect those two up to make a complete entity.
Right, now, I'm thinking now about the setting of One Lochhead conservation area. So, if we have a look at FEI figure 10.1, that's the cultural heritage assets within the inner study area. If you could get that.
10.1.
Have that now. Firstly, what I'm interested in, there's two aspects here. So there's a vehicular approach. So I'm interested in the context of the setting of the conservation area, the approach from the Mennick Pass from the south, and also the approach from Lead Hills going south.
Yep, got that.
Could you explain the setting? Is there any aspect of those approaches which affects the setting or would be affected by the setting?
The approaches to the village, but from both directions, are a part of the setting. I think setting is much more than simply just views, but views can be an important aspect of setting. That's true, and certainly the approach to a conservation area is one of the important views of, or one of the important aspects of the setting of the conservation area itself. But it's not the only one. It's not necessarily the main one. It's one that. That's the perception of the village or the conservation area as you enter it.
That's what I'm trying to understand here. Are these approaches important in the setting of One Loch Head Conservation Area?
I think it could be reasonably said that the road, as it travels from Clydesdale to Nithsdale, is, as it passes through these passes here, is the reason why the village is sited where it is. It's at the head of the communications network, and also there's a communications network or communication line going along the One Loch Valley as well. So you're at if you like, you're at I'd hesitate to call it a crossroads because it's only three, but I don't know what you'd call a junction, I suppose.
And is there any element, and you won't have been here last week when we had I can't remember the author now, there was a reading from the 18th century of coming up the Mennick Pass. Is there a feeling, because you know that setting, as you say, encompasses more than some physical attributes, is there a feeling of anticipation that you might be coming upon One Loch Head?
To my mind, no. I think it comes as something of a surprise when you travel up the Mennick Pass and you come round the bend, and then the village is suddenly there in front of you. And it's much the same when you're travelling from Lead Hills, in my experience. You know, you come over the cattle grid, and then the ground suddenly drops away in front of you, and the village is there. So you're almost in the village before you see it.
So that would lead on to the question of, if it's suddenly before you, you'll be aware that principally you might be looking across the village and down the One Loch Valley. So would the wind farm that's been proposed, would that affect the setting of the village in those circumstances?
It would certainly be an element in the background of the village, yes, and to some degree it does affect the setting, certainly, and I think that's recognised in my assessment in the environmental statement. It's not about a single viewpoint, though. One has to sort of consider setting and around, and you know, the setting of the village is very much experienced as one travels around the village, I think.
Thank you. If we could now look at walking routes into the village in terms of the setting of the village and the importance of these walking routes. So the ones I'm interested in are, there's a route you'll see to the west of the plan here, around Bradley's cog. I don't know if you can see that. Near the number 75, there's a brown line, and the brown line follows the Glendyne Burn up past Willow Green Hill, Stood Hill, Black Hill, and into the village.
Yes, I think that's the brown line in the south. Yeah, the brown dash line in the south. Yeah. That was identified as heritage sites number 53, which I think is, and I'm sure that the villagers will correct me here if I'm wrong, but I believe that's one of what is known as the Coffin Road.
Yes, indeed, that's the case. Yeah.
Is that the case? Yeah, it was never quite clear to me whether that was the case or not. But that was a route taken by mourners taking burials to Sanquhar before the church was built at One Lock Head. So when all burials had to be taken from the village as far as Sanquhar, rather an arduous task, I think.
So in that context, is this route important then? Are you saying that this route is really from travelling from One Lock Head to Sanquhar rather than the other way around?
Yes, but no. It may also. It's also a route that leads into the village from Sanquhar, and as One Lock Head was an industrial site in the 17th, 18th, and 19th centuries. Then it can be reasonably expected that people were travelling from Sanquhar to One Lock Head. So travel in both directions would have been relevant along that route. Yeah.
So there's just one other route, and that's the one along the Southern Upland Way. And I'm just interested in both these routes coming into the village, how important walking these routes is to the setting, particularly when you've gone down Glengabber Hill to the east, and then you've joined, I forget the name of it, I think it's Church Street, on the approach up to One Lock Head.
The view, certainly the approach from the Southern Upland Way would be it's a contributing factor to the setting, yes. And I would agree with you that the approach along the southern footpath, or the Coffin Road, shall we call it, was equally contributes to the setting, because that comes into the village from quite a high elevation on the hills, and you're looking down into the village from that location and walking down into it. But I get no sense that the proposed development would be visible or would interfere with that the view of the village in that approach. And likewise, coming from the Southern Upland Way, the proposed development would not interfere with the view of the village or the appreciation of the character of the conservation area in that approach.
Now, I realise that you haven't had a chance to review this, but if you could have the Harryburn decision in front of you one more time.
Okay, yes, I have that now.
Thank you. Now, I just want to draw your attention to paragraphs 4.58 to 4.60. I'll just give you a second to have a read over those.
.58 to 60.
4.58 to 4.60, 3 paragraphs.
Yeah, I've read those now, yeah.
Right. Now, so my understanding here, there's a critique of the methodology used in the environmental statement and the reassessment regarding the level of significance of non-scheduled monuments. Now, looking at your plan, figure 10.1, can I just confirm the yellow dots and yellow areas, those are non-scheduled items, is that correct? Or are there any non-scheduled items within the application site?
The yellow dots on this map refer to non-designated heritage assets. So they're effectively sites that are not listed buildings or are not scheduled monuments. In that regard, there's no differentiation between whether they're of regional or local or even negligible significance or what we would call sensitivity rather than significance. There's a lot of confusion within the profession. Some people will use significance, other people will use importance, some people will use sensitivity, other people will use value. The recent documentation that's come out from SNH and Historic Environment Scotland in the 2019 guidance actually uses the terminology value and sensitivity.
What I want to understand is, I'm sorry to pull you to another document, but in the ES, table 10.2, sensitivity of heritage assets, if you have a look at that.
Sorry, sir, what was the reference, ES?
It's ES, table 10.2, it's in volume 1.
Yep, okay, I have that now.
Now, in relation to Harryburn, the reporters were critical of the approach taken to the reassessment, not to the environmental statement approach. What I want to be clear on here is, in terms of you assigning significance to any of these non-designated items, what have you assigned to them? Is it medium and low significance to regional local monuments, or is it something different? Could you explain that to me?
In my assessment, we have to take a judgment. Sites of national importance in this table are set out as high. This table sets out at high. It excludes from that World Heritage sites, which, if there had been any, might have been placed in there at a very high category, so at the highest level. High, medium, low, and negligible really relate to and I say this is these sort of terminologies are kind of largely, if you will, sort of superseded by the recent HES guidance, which does sort of provide a little more clearer guidance on how we might use terminology more accurately, because the definitions of national, regional, local, and little or no importance go back to sort of the NPPG days, so we're using terminology that's sort of somewhat out of date, shall we say, and it's no longer recognised in planning policy terms. And that equally applies to the classifications of listed buildings, which formerly had those sort of classifications, national, regional, local for A, B, and C. And that's no longer referenced in the relevant planning guidance. So these sort of terminologies are somewhat out of date. But in the context of the question that you've asked me, then all scheduled monuments are of national importance and therefore equate to the highest level in this table. Assets or sites of regional importance or local importance becomes a sort of a professional judgment as to whether they contribute to sort of regional research frameworks, whether they're important within a regional context. And that might relate to, they could be sort of like medieval settlements, well-preserved medieval settlements that contain a lot of archaeological information and historical interest, or they could be, less well-preserved examples of small post-medieval farmsteads or something of that nature. They could be prehistoric sites that are, prehistoric settlement sites that are quite extensive and would, add to our understanding of life in prehistoric times, or they could be an isolated prehistoric hut circle, which is arguably of a lesser significance or more valued at a local level. So they fall into these different categories of medium, low, and then negligible is really a category that's reserved for sort of very minor features that don't add anything particularly to our understanding of the historic landscape of that nature. Yeah. If that answers your question.
I understand how you've attributed them. What I'm trying to understand is whether or not you have assigned the level of significance which the reporters at Harryburn found fault with, or whether or not you've assigned the correct level of sensitivity to each of these assets.
Without seeing the tables to which the Harryburn reporters refer, it's very difficult for me to say that. Without to go into criticising other professionals' methodological approaches, I don't have that information in front of me to make a value judgment as to the difference between what was assessed in the ES and what was assessed, or how these things were assessed in the additional information. All I'm going on is that this is the approach that we have used up until certainly this year, where we've slightly adopted the SNHS guidance and revised our methodological approach to more accurately reflect the way that sort of HES have shall we say, changed the sensitivities of these things.
I think if I put it another way, having read those 3 paragraphs in the Harryburn report, it appears that the ES originally attributed a high significance to regional non-scheduled items, and the reassessment gave them medium significance. That appears to me what you have done, and I'm just trying to confirm whether or not that's correct or not.
I'm not sure that's actually what these 3 paragraphs say. If I may be so bold as to actually read them out to the inquiry.
It's fine. If you're not sure and you've made your caveats, it may be a point for re-examination, or indeed I can read over and come to my own conclusion.
Well, it seems to be that in paragraph 458, it says that non-scheduled monuments have either a high or medium significance, depending on whether they are of regional or local importance. Further down in 460, it says non-scheduled monuments are either medium or low, depending on whether they are regional or local. I take your point, and I would err on the side of 460 myself.
That's the crux. That's what we've been talking about for the last 5-10 minutes. Does your table 10.2 adopt that approach?
The table that I use, it follows the approach that's in 460.
Thank you. That's the end of my questions, Mr. Steele.
Thank you, sir.
I do apologise for that, sir.
Mr. Moody, let's just take a moment or two to consider that, if we may. Could we look, please, at 460 of the Harryburn decision? I'm just dealing with this first because I have all the documents out. And concentrate on the first sentence. We note that in the additional information, scheduled monuments are not given the highest significance. Instead, it considers their importance as high, distinguishing between international and national importance. Now, can I just ask, please, what is your approach in relation to scheduled monuments?
In terms of scheduled monuments, I would always assess those as being of, shall we say, high sensitivity.
Indeed. And I think that's what you said earlier. So that if in the assessment set out at Harryburn they appear not to be given the highest significance, does your methodology agree or disagree with that in relation to scheduled monuments?
In relation to scheduled monuments, in the table that I employ, the high sensitivity is the highest sensitivity in that table. As I said a little earlier, that had there been World Heritage sites which are of international importance, they would be in there as of very high sensitivity.
Even higher. But so far as scheduled monuments are concerned, have you attributed to them the highest significance in your table or not?
The highest significance in that table, yeah.
And if we then look at paragraph 460, the first sentence, does it appear that a different approach has been taken by the assessors in the Harryburn case in relation to scheduled monument?
It does on the face of it, certainly.
And I mean, you take time to answer this. Does it appear that the criticism of the reporters in that case is for not attributing the highest significance to scheduled monuments, which, in fact, you have done?
I have to be cautious here, Mr. Steele, because I don't have those tables in front of me in order to make a comparison between the two. But it does seem that I think this is where my confusion arises, because I don't actually understand the methodological approach that's been adopted here. That the highest significance has been subdivided into international or national importance.
And is that approach that you've adopted, or have you simply said that scheduled monuments are of the highest significance in your table 10.2?
I've attributed scheduled monuments the highest significance in my table 10.2.
And that being the case, you have not followed the methodology which has been criticised, appears to be criticised by the reporters at Harryburn. Is that correct, or am I missing something?
On the evidence before me, that would appear to be the case. Yeah, Ken, as I say, I have not got these tables to make direct comparisons, so I have to reserve judgment on that.
And in relation to the yellow dots in your plan, these are non-designated assets, is that correct? They're certainly not scheduled monuments, but they've got no other designation either, is that so?
That's correct, yes.
And
just for the record, they include assets that are taken from the historic environment record, sites that are identified through other desk-based research, including research of historic maps, and the results of field surveys. So it adds to assets that are recorded previously in the historic environment records themselves, yeah.
So there's a whole range of assets covered by your yellow dots, but this is a specific point, they are not designated at all.
That's correct, yes.
Is it to those that you said you took a value judgment depending on exactly what they were?
That's correct, yes.
I don't know, sir, if that assists in any way. Can I just take you, please, then, to the question of the approaches to Wanloch Head and whether that does or does not contribute to setting. Could you look, please, at document JW7? I don't know if you've seen this before or not, Mr. Moody, but it's a plan demonstrating theoretical visibility, only theoretical visibility, on the approaches to Wanloch Head.
I've not seen this document before, no, Mr. Steele.
Well, to save time, let me identify to you that the blue area of the road is what might have theoretical, which does have theoretical visibility, may therefore have visibility of the proposed wind farm.
Yes, I see that, and that would be my appreciation as well. I think that's what I tried to convey.
So that when we
to the reporter
approach
before.
Wanloch Head from the generally northerly direction, is it only when one is almost in the village that there's even any theoretical visibility?
That's correct. I think that's what I said earlier on, yeah.
And likewise, approaching from the south, through the bottom of the Menloch Pass, Menloch Pass, again, is it when one is very close to or actually in the village before there's even any theoretical visibility rather than actual visibility?
That's correct again, yes.
Just using this plan for the approaches, firstly by the Coffin Road, and can you just tell me or remind me where that is? That was the one you were asked about earlier.
On this plan, that is shown as the dashed line which runs over Stood Hill.
And Stoot Hill, I suspect by definition, it would be a hill. And is it when one drops down from Stoot Hill into One Loch Head that one would get visibility of the village?
On this plan, I think that would be, looking at this plan, I think the first view, I'm not entirely familiar with that particular route, but I would say, looking at the plan and taking account of the topography, I would say that in actual fact, it's when you reach the top of the watershed at Black Hill.
And can you give any impression or evidence in relation to what might be the effect of the setting from coming down from Stoot Hill to the village, given the location and disposition of the turbines and one's progress towards One Loch Head? What might be the effect on the setting?
Well, we wouldn't see the turbines in conjunction with the conservation area of any elements of the village of One Loch Head. The turbines, the proposed development, would be well off to one's left-hand side.
And I think, if I got this right, you're also asked questions about the southern upland way and dropping down from Glengaber Hill towards the One Loch Water and the village, if I got that right. Mr. Moody, if you understood something else, just say so.
That's the way I understood the question previously.
And if one is dropping down from the general direction of Cogs Head down to the One Loch Water, what do you say would be the effect on the setting of One Loch Head on that route, given the precise location and disposition of the turbines?
I don't think that you would actually see One Loch Head from the southern upland way when you descend in Glengabber Hill. I think it's only once you're actually within the valley and walking along the One Loch Water southwestwards towards the village that you would actually start to see the different elements of the village at first approaching the church at the bottom.
When you say southwest, do you mean southwest or possibly?
I beg your pardon, southeast.
And at that point, would one have one's back to any view of any turbines that there may or may not be?
That's correct, yes.
So what do you say on the walking route approaches that have been put to you about any effect on the setting from the proposed development?
I say that you, on those walking routes, one's appreciation of the setting of the village would not be affected by the proposed development. In that regard, I would further say it would be instructive to look at the two viewpoints from the lower end, the northwest end of the One Loch Valley that were presented in the environmental statement, which showed the limited amount of visibility of the turbines from those locations at that northwestern end as one, and they would be to your back as you're approaching the village and walking towards the cemetery and then beyond and into the village.
Thank you very much. I hope that's helpful, sir. I have no further questions. Thank you.
Okay, thank you, Mr. Moody. We'll just take a couple of minutes while we swap over for Mr. Godfrey. Thank you.
Mr. Edwards, I have a couple of plans which were basically scheduled. They were the plans that accompanied the schedule for One Loch Head remains, and I didn't attach them to the document that I cited earlier. Would it be possible for me to, I've got copies of these plans, would it be possible to pass them to both parties and yourself and put them in as an extra document in our list, please, so it would become WL11.
I'm assuming these are the plans that are appended to the back of the scheduling description.
That's correct, yes. I think they would help illuminate the situation.
Sir, I don't mean to be difficult at all, and I've been trying to assist Mr. Godfrey, and in addition to that, he has been cut quite a lot of slack, one way or another. It is most unfortunate that any document should now be produced when my witness has finished. If it relates to the actual scheduled areas, which I understand it is, I would have thought that is in any event covered by the plan which we've been speaking about, and I'm not sure why, if that's all it is, it would be necessary to lodge them. If there's to be something made of this that's different to my understanding, well, I really do need to know about that. We need to consider it, and Mr. Moody needs to. So my initial reaction is one of caution, and it's really a little bit late in the day to be producing these.
Sure. Mr. Godfrey, the appendix to the inquiry report from Mr. Moody appears to show these boundaries. Is that not one and the same?
The boundaries in the plans that accompany the schedule are the same, but they show the contours in much better definition, so you can get an appreciation of the impact that the schedule areas are not just flat, but give some appreciation of the height that they extend to.
Okay, and it's specifically the scheduling around One Lockhead that you're interested in. Is that correct?
Specifically that, yes.
Right. In that case, FEI figure 10.1 is an ordnance survey base, and it does show the contours in quite good clarity. I think we could probably just use that rather than submitting another document at this stage.
Sorry, what was the reference number, Mr. Edwards?
It's FEI figure 10.1, cultural heritage assets within the inner study area. And it's to a scale of 1 to 35,000 to A3. Okay, so we'll just take a few minutes. Right, thank you, everyone. Mr. Godfrey, looking at your landscape and visual amenity precognition, I've identified a few paragraphs, 4.1, 4.2, 11.1 to 11.4, which appear to encompass cultural and built environment issues. My understanding is that you're going to select a few paragraphs to read out, but not.
Yes, that's the case. I did have a look for that document FEI figure 10.1, and I couldn't find it. I wonder if perhaps Mr. Innes could assist me in this. I don't know. It's FEI figure 10.1. Thank you. I don't want to. Oh, that's brilliant. Fantastic. What I've done is I took the paragraphs out of the landscape section, which I thought were relevant, but obviously it looks like I've taken fewer paragraphs than might be the case. I'll start at as described in section 4 of the landscape document. I've scrubbed the paragraph numbers, I'm afraid, because I put them together here. So I don't know what that particular paragraph number is. So, as described in section 4 of the landscape document, both villages have a profound sense of place and pride in their mining and...
Sorry, just for everybody else's clarity, it's paragraph 11.2 of the recognition that Mr. Gorky is reading from.
I'll start again. As described in section 4 of the landscape document, both villages have a profound sense of place and pride in their mining and cultural heritage. Both villages are designated conservation areas, both contain a Grade A listed building, and both villages have a close relationship with the remains of the lead mining industry, which run along the flanks of the Wanlock Water and the Glengonna Water. These remains are the most extensive remains of the lead mining industry in Scotland, and they are designated as scheduled monuments. The view down the Wanlock Valley from the village to the remains of the new Glencreef mine and beyond epitomises this sense of remoteness and the connection between the settlement and its historic mining routes. The proposed development will impact upon the setting of the village in an extensive and the extensive schedule remains of the lead mining industry by introducing discordant and dynamic elements unsympathetic to the setting of the village and its backdrop along this key visual corridor. I'm very, very conscious that in the photomontages, the turbines, obviously the impression that you get that you see them there, but in the photomontage they're static. In reality, they will be moving, and I certainly feel that one's eye would tend to be drawn towards those turbines. Right. Next paragraph I want to read out starts, the detrimental impact of the turbines on the setting of the village is illustrated by viewpoints in the original environmental statement. The photomontage at viewpoint 4 at the upper end of the village shows 13 turbines. That shows 13 turbines will be visible above the ridgeline of the valley. The hubs of 7 turbines will be visible along with the tips of visually disembodied turbines. They will break up the framing of what would otherwise be an enclosed vista, particularly when rotating. The photomontages at viewpoints 3 and 2, again I give sort of references there, both on CD 1.2, illustrate that the number of turbines visible above the ridgeline reduces as one moves northwards through the village to the historic beam engine, which is itself a scheduled monument. And I think I would add at this point that the beam engine differs slightly from the other scheduled monuments within the area in that it's actually actively maintained by Historic Scotland. Next paragraph I'd like to read out is substantial areas of the floor and lower flanks of the Wanlock Valley, as viewed from the village, form part of the extensive schedule monument. Although not directly physically impacting on the cultural designations, the proposed development will adversely impact on the setting of this scheduled asset and will also impact on those of the beam engine and the Wanlock Head conservation area by adding a contemporary alien element into the landscape. I was going to make some comments about the vertical dimension to the schedule areas and the conservation area, but I think we've already touched on that, so in order to save time, I won't pursue that further. Earlier on, I did draw attention to the particular view down the valley, which was shown in viewpoint 4 from Upper Wanlock Head, and the turbines on the skyline. You see parts of those turbines, and you see a number of hubs, and you see quite an extensive number of blades, and I just think that in a dynamic situation, those particular turbines will detract from the setting and ambience of the village. Strangely enough, I was out walking the Southern Upland Way at the weekend and got a real soaking, but that's by the way. But I met a chap from Sanquhar who walks quite often to Wanlock Head, and he said, what I like about the village is it never seems to change, and certainly if the proposed development goes ahead, there will be quite a significant change, certainly in my view, in terms of the setting of the village. Okay, that's all I want to say. Thank you.
Thank you, Mr. Godfrey. Ms. Gibb, Ms. Richford, any points of clarification, or can we continue to cross-examination? Okay. Mr. Steele.
Thank you, Mr. Godfrey. Good afternoon.
Good afternoon again.
Can I just confirm, as I did earlier, that you've got no particular qualifications in relation to matters that we're discussing now, namely cultural heritage?
In relation to cultural heritage, I don't, but I did do a course in building design in Amsterdam, in actual fact. It was conducted in English. So I've got some appreciation of aesthetics, if you like.
Insofar as scheduled monuments are concerned, do you accept that Historic Environment Scotland are the guardians of scheduled monuments and their settings?
I do indeed, yes.
Could you look, please, at document CD 2.13?
Sorry.
Now, can we agree that that is a consultation response, Mr. Godfrey, from HES in relation to our application?
Yes, we can agree that that's consultation response.
And that they have assessed the monuments and their settings, and after evaluating the matter, they do not wish to raise an objection.
Yes, that is the case.
Now, if you could possibly pass me that folder back, then we may have to share again. In relation to matters more generally of cultural heritage, do you accept that Dumfries and Galloway Council have got properly qualified experts who are consulted and respond on these matters?
Yes, I accept that that is the case.
And could I ask you please to look at CD 2.36? And can we agree that in this consultation response, the relevant experts of Dumfries and Galloway have looked not only at the archaeological sites, but also at the village of Wanloch Head and its heritage assets and the conservation area issue? Page 4, the top main paragraph starting the village of Wanloch Head, I think is probably the best place to look.
Thank you. Yes, I've looked at that, yeah.
And the recommendation is one of no objection on cultural heritage issues.
Yes, I accept that is the case.
Right. So the question then is this, Mr. Godfrey, do you agree or disagree with Historic Scotland in relation to scheduled ancient monuments, firstly?
We're looking at things from a sort of local perspective, and our perspective may be slightly different to that of Historic Scotland and indeed the Council.
Firstly, do you agree or disagree with the judgment, professional opinion of HES on these matters?
Yeah, I feel uncomfortable about this, but yeah, I think there is an element of interpretation, but broadly speaking, I think I would have to go along with that.
Go along with what? Go along with HES?
But along with the HES assessment.
And if you go along with the HES assessment, there is then no reason for objection in relation to scheduled monuments and their setting.
I'm not going to fall into this one again. In that, I think it's a question of, it's a matter for the reporter as to what weight he puts on my view and the views of the community.
And Mr. Godfrey, in relation to the village conservation area and its setting, do you agree or disagree with the judgment of the relevant officials of Dumfries and Galloway Council?
Yeah, I think there is some difficulty in respect of the conservation area because the actual document that scheduled the area would appear to be missing from, and nobody at the council was able to furnish me with a description of the document, despite having taken a lot of time and effort to see if they could come up with it.
Well, I'm not sure I understand that, but do you agree or disagree with the professional opinion of the officials of Dumfries and Galloway Council?
Broadly speaking, yes.
Well, you either agree or disagree, Mr. Godfrey.
Yeah, I will agree.
Thank you. Now, could I just, for completeness, please turn to Mr. Moody's inquiry statement at page 15 and 16. I'm not sure what this is, but I think so. think so for now. Thank you. Do you have Mr. Moody's inquiry report?
Right, I have it now.
Could you turn to page 15, paragraph 78? And
Sorry, paragraph 78.
paragraph 78, where there's a quote from the findings in relation to that case at Cregan. Now, do you understand that there's a difference between a mere alteration to the setting and whether it diminishes the understanding and appreciation of the assets and the integrity of the setting? These are two different issues.
Yes, I mean, to my mind, they're almost similes, insofar as they're almost expressing the same thing, in my view.
Well, that may be the difficulty then, Mr. Godfrey, because in this case, another two we'll look at in a moment, a clear distinction is drawn between the mere alteration of the setting and actually affecting the integrity of their setting.
Yes, I do appreciate the difference.
Right. And if we could look just at the Cregan case, just out of interest, please, which we've lodged CD 711. Paragraph 4.42.
Sorry, Kate, core document reference again, thank you.
711, sir. Sorry. 712. Sir. Whichever it is. On the right-hand column. No, just keep that page open, please. On the right-hand column, at that paragraph in front of you, Mr. Godfrey. On the right-hand page, the one that I can't see the number because you got my copy, but that paragraph there. Could you just give me the number of the paragraph for the reporter's notes?
4.41.
Do we see that there's a reference to Dr. Carter? And I can't remember the precise wording, but is there a finding that Dr. Carter had rather understated matters in relation to significance in that paragraph?
In italics?
I think so. I can't see it. It's the one underneath it.
4.42. Yes, the reporter was less persuaded by Dr. Carter's approach.
Less persuaded than by the evidence of who, do you know? Is that mentioned there, or do you know if...
it's not, but no doubt you're going to tell me.
Well, if we look through the document elsewhere, I think you'll find it's the good Mr. Moody who's sitting on my left-hand side.
I'll accept that that is the case.
And do you know if it was Dr. Carter that gave evidence at the Harryburn inquiry where the reporter, other two reporters, seemed, from the paragraphs we looked at earlier, to be of the opinion that he'd rather understated matters there as well?
There were two gentlemen gave evidence in respect of heritage and cultural aspects, and I can't remember either of their names, I'm afraid.
Well, we can look at the Harryburn decision because they're clearly listed there. Now, turning back to paragraph 79 of Mr. Moody's report, do we see there in relation to Corlick Hill, where to save time Mr. Moody also appeared, the findings of the reporters in relation to the forklet, Roman forklet, related to whether the integrity and the ability to understand the monument was affected or not. Do we see that from a reading of the bottom of the page and the top of the next page? Last few words, not undermine the integrity of the monument setting.
Yes, I accept that that is the case.
And finally, at Harborne Head, which is the next wind farm listed there, do we find a similar approach? It's not merely having an effect, or indeed there a significant effect, but whether it was something rather more than that.
Yes, I agree that that is the case as reading that paragraph.
Do you suggest anywhere in your evidence, Mr. Godfrey, that the integrity of the setting of monuments would be affected?
I do not believe I do so.
To be able to proceed to implementation in an increasingly competitive environment and therefore contribute to the Scottish Government's and the UK Government's targets and policy objectives. The Scottish Government is committed to overcoming barriers to support growth in onshore wind. This is one such site that is effective and deliverable in a subsidy-free context. In terms of SPP, Scottish planning policy, the site can be regarded as Group 3, indicating the location is likely to be acceptable. From the review of SNH papers, it would seem SNH set its face against the North Lowther project from the outset and looked for a national interest case with which to oppose the application, which found principally in a map which divides all of Scotland into distinctive areas. Not surprisingly, SNH found the location to be regionally distinctive. The applicant's landscape architects have undertaken a detailed assessment of the site in the wider landscape context and arrive at a different position to SNH. Although the application is opposed by SNH, that does not mean the application should be judged to have unacceptable impacts. As I point out in my inquiry report, the issue is not so much the process itself that SNH has followed, but the information that has informed that process and how it was established and how the tests of national interest published by SNH itself have been applied. It is important, therefore, to establish if reliance can be placed on the SNH evidence. If the significance of the adverse impacts has been overstated by SNH, while the weight of economic and environmental benefits has been understated, then the balance called for by the exercise of the SNH statutory duty could have been different. The SNH position on the application does not prevent a finding that this is the right development in the right place, having regard to the statutory duties for a Section 36 wind farm application. Decision makers are not bound to follow the SNH position. This has been most recently shown in the Limekiln Section 36 case, in which there was an SNH objection on landscape and visual grounds, but the reporters judged that development proposal to be acceptable, as did the Scottish ministers. The decision on the North Lowther project should not be taken by reference to the predicted landscape and visual impacts alone. Other relevant considerations will include the considerable support that the application receives from the intensifying urgency to meet renewable electricity and emission reduction targets, particularly now that the support mechanisms have been withdrawn for onshore wind. The North Lowther project is viable without such support. The project is coming forward in a context in which what might be termed easy wind farm sites have been developed, financial support mechanisms have been withdrawn, and technology has advanced considerably. Furthermore, the application site can be regarded as Group 3, is in a scale of landscape in which it can be accommodated and does not engage issues in relation to residential amenity, national scenic areas, national parks or wildland. Moreover, the applicant's approach is unusual with regard to the extent to which it has worked to maximise the net economic benefits, as explained by Mr Blackett. In addition, in terms of a key environmental issue, the applicant has gone beyond the standard mitigation with regard to hen harriers and their habitat. This development can play a key part in the species recovery. Policy IN2 of LDP2 specifically requires consideration of the scheme's benefits to be taken into account. The benefits need to be considered in the context of the current climate emergency to address the crisis issue of global heating and with the need for urgent action and world-leading targets that have to be attained. The Committee on Climate Change's advice is clear in that global heating is speeding up and the response to it has not been quick enough. The debate has firmly shifted in 2019 on the need for transformation action, and the planning system has a critical role to play in that regard. The overall conclusion I reach is that proposed development satisfies the terms of Schedule 9 of the 1989 Act, taking into account other policy considerations, including the current adopted development plan and associated supplementary guidance, and the proposed LDP2, as we will come on to discussing.
We'll come on to that just in a moment.
Has been adopted. On this basis, I respectively invite the reporter to accept my evidence and conclusions that Section 36 consent and deemed planning permission should be granted for the proposed project.
Now, Mr Bell, a number of additional issues have arisen, but the first one to discuss, if we may, is the question of the development plan and related supplementary guidance position in light of the either adoption or imminent adoption. I'm not sure if that's been clarified today, but either way, I think it makes no difference.
I think it's being taken as formally adopted on last Friday. I think it was published on the website then. It's certainly on the website now, and it's from publication that matters. So whatever, whether it's last Friday or today or yesterday, for the purposes of this inquiry going forward, it can be taken to be adopted.
Well, we're proceeding on that basis, Mr Bell, is that so? So can you just explain what that means to your evidence in terms of the development plan and in terms of the supplementary guidance?
Thank you. Yes, that's helpful. I addressed the relevant policies of LDP2 in my inquiry report. That's page 22, where that starts. And the approach I took was to place more weight on those policies and that plan in any event than the now departed LDP of 2014, which now falls away. It's superseded. LDP2, that's the new adopted plan, is, in my view, an important consideration to be afforded significant weight. But, as we know, there's no primacy of the development plan, as there would be under Section 25 of the 97 Act. There's agreement amongst parties on that. But an important consequence of the adoption of LDP2 is that there is no longer any statutory supplementary guidance, including the landscape capacity study. And I addressed that in my inquiry report at paragraph 3.3.2, anticipating that that would be the case on adoption of the plan. That is because the parent policy in an adopted LDP is no longer there. And that would be as per Section 27(2) of the Town and Country Planning, Development Planning Regulations. That makes it clear on that position. Therefore, we have an adopted LDP, but only draft supplementary guidance and a draft capacity study in place.
And it perhaps goes without saying that the draft SG and capacity study would attract less weight, limited weight in these circumstances. Is that so?
Yes, that's right.
The next topic is the programme for government being a new document. Do you have any additional comments to make about that?
The government's programme for government was published on the 3rd of September, so I addressed it in my precognition in the section I did not read out. It is document NLEI 27. I think the key point, I would say, is that it is a clear acknowledgement from the First Minister of the climate emergency, and the introduction is clear where the First Minister says we need to redouble our efforts in terms of achieving net zero. And it also, on page 39, refers to planning, the planning system as a vital tool in leveraging changes needed to achieve goals. I think the third point I would just say about it is that the response group that the government has set up does make it clear that one of the actions will be establishing the extent to which renewable energy generation is needed to meet net zero. The anticipation being that it will be more than currently is set out in targets that go to 2020, for example. So that's all I wish to say really on that document that is the latest position from the government on net zero.
Climate change bill, Mr. Bell.
Yes, this is another change. In my inquiry report, I make reference to the Climate Change Emissions Reduction Targets Bill. This is on page 67 of my inquiry report. And the bill went through its stage 3 in the Scottish Parliament at the end of September. That's the 25th of September. It's now passed and will move to enactment. And one of the important changes that was agreed during the debate in the Parliament was the strengthening of the interim target for 2030, which is moving from a 70% reduction in emissions to 75%. And the key world-leading target remains of net zero emissions by 2045, 5 years ahead of the UK.
Sorry to interrupt you. Over what figure?
The reduction is over the baseline figure of 1990.
So, in short, what do these factors mean for the advantages of our proposal in terms of the need case for meeting government targets and or requirements? Mr. Bell, does that enhance our position or weaken our position?
I think it enhances it. I've set out on section 2 of my inquiry report the position that things have changed in 2019. We've had the Climate Change Committee report, the IPCC report. Just yesterday there were almost 350 arrests in London, people gluing themselves to roads. So what I would say is global heating is not a scenario set out in an appendix of a Climate Change Committee report. It is an issue that all levels of government are grappling with as a declared emergency. And these latest positions add to the growing position of what I would call the need case and the significant weight, in my view, that should be attributed to that.
And do you say that greater or lesser weight should be attached to the need case than even at the time that you wrote your inquiry report? Have matters moved ahead a little bit even since then?
It is a fast-moving area of public policy, and insofar as the statute has been, targets in that have been amended, then yes.
Now, Mr. Mundell made various claims in his evidence, but one in particular related to community consultation, Mr. Bell, and you'll recollect he said that, and the learned reporter asked him questions about that. Now, what is your evidence about the matter, rather than Mr. Mundell's speculation?
I was quite surprised when I perceived him as saying that there was very limited public consultation and engagement. But there is a pre-application consultation report before the inquiry. It's CD 1.5 that sets out the detailed objectives of community engagement and, for example, cover some detail on the 3 rounds of public open days that were held. That's section 2.4 of the PAC report. Refers to the meetings with community councils and the meetings with residents held on an individual basis if necessary, and the website that was prepared with updates of information and so on. So, in my view, having reviewed that, I think there has been considerable public engagement, and beyond that, the applicant has taken on board issues raised by consultees and other parties in making amendments to the scheme as it progressed through its determination with the Council, and that is set out in the PAC report.
And did you also say that the opinions, concerns of various parties, including local residents, have indeed been taken on board?
Some have, yes, as set out in the PAC report.
And in that regard, do you agree with Mr Mundell, who said that these concerns had effectively been ignored by the developers who preferred greed rather than take these matters on board? Do you think that's very fair?
It's certainly not the case, and unfair to describe it as such.
Shared ownership. Can you tell us the position about shared ownership, please?
Yes, it has been offered. In the planning statement, it's referred to at section 6.2, page 76. And the current position, as I understand it, is the Sanquhar Community Council and Upper Nithsdale Community Trust have advised that they do not want to take forward community ownership discussions, as they are not keen to take on the liability and wanted to concentrate on community benefit, more conventional approach of community benefit. And I understand that position. It's not uncommon, as not all local organisations have the capacity to take on the commitment of shared ownership. And also, I think it's fair that communities and organisations tend not to engage in detail on it until there is the certainty of consent, where they can then look at feasibility of that with more certainty. All that said, it is an offer that remains on the table with One Lochhead Village Council, should they wish to take it up. And I would say that offer is not just limited to those bodies. The applicant would be willing to discuss it with other parties should they come forward. And my understanding is that the applicant has had some follow-up meetings with One Lochhead Village Council. I think the last one, I understand, was in December 2018 to discuss matters, although they have not yet received a response back from that. But I would reiterate, the offer is there for that discussion to be taken up at any point.
Grouse moors and all the keepers being sacked, or words to that effect, Mr Bell, do you have any evidence to give us about that?
I was surprised to hear that in the exchange yesterday, and I've spoken to the applicant and indeed the estate, and there were no keepers have been made redundant since 2012. So there's been no job losses as a result of this application. It's simply not right. And it is right, though, that there has been a reduction in grouse shooting, but that's not uncommon across a wider part of Scotland, where there is greater vibrancy in lowland shooting. Well, that's pheasant and partridge, but grouse moor numbers have declined, not just here. And one of the factors in that has been the very cold winters, the beasts from the east in more recent years, and before that the previous very cold winter. But it's a complicated. There are complicated reasons behind grouse decline, and it's not simply localised in this one area. It is a wider phenomenon.
Yeah. And in any event, would it be possible and practical to have grouse shooting, supposing there were enough grouse, of course, even if wind turbines were constructed? Are they mutually exclusive?
No, they're not. And there are other examples where the two go ahead together.
So any suggestion that keepers have been paid off or grouse shooting stopped because of the wind farm, would there be any basis in fact for that?
No.
Now ask you about the North West Lowther unit, and in particular at Spango. Have you had a chance to look at that, and do you have any evidence to give us about that, please?
Yes, I've had a look at the position of it, and I'm grateful for the bundle of papers that came in today on it. It's very helpful.
Wait a minute, Mr. Bell. It's CD 7.53, I think, and 7.54.
Yes, that's right.
And this was an application and a refusal for a wind farm in the northwest Lowther area, namely within the SPA. Is that correct?
Yes, I think the northwest unit was discussed in the landscape evidence in terms of the capacity study. This application was 14 turbines, 145 metres to tip, about 50 megawatts. It was 49 megawatts. Refused permission on the 24th of September 2015. Reasons, in summary: unacceptable impact on the Muirkirk, North Lowther and Uplands SPA, and on the related SSI, designated for breeding birds. Also, significant adverse landscape and visual impacts on character area 19, it's Northwest Lowther unit. Impact on receptors in the Croic Valley, cumulative impacts, and impacts on Lowther Hill radar, and an SNH objection with regard to the SPA impacts, which altogether I'm not surprised to see given location within the SPA, which is unusual to see. I think there is a helpful map as well that came in at the end of that bundle, which illustrates the turbine locations indicatively within the SPA, just to the northeast of Connell.
Do you say that these reasons for refusal, which you briefly summarised, appear to be pretty formidable, or something that could be easily remedied?
It doesn't look like a marginal case. I mean, it looks fairly, I was going to use the word overwhelming in terms of reasons for refusal. It would be a very high-risk site, in my view, in terms of prospects for attaining consent, principally the SPA matter, which I can't think of wind farms that have been successfully developed within SPAs.
And you've got not only an SPA here, but a triple SI. I mean, realistically, what to you as a professional judge would be the prospects of success in an SPA and a triple SI, never mind the rest of it?
Very difficult. I mean, I'm looking at the north end of this area at the moment, near Middlemuir and Andershaw, that area. And it's, the SPA coverage is extensive on this side of the valley, on the north side of Croic. Very difficult to see how very limited areas of Group 3, so very difficult area, I would suggest.
And if it was suggested, as I thought it was, but I'll no doubt be corrected, that there might be scope for turbines, suggested by Dumfries and Galloway, that there might be scope for turbines in this unit, the Northwest Lowther unit, do you think that's realistic and feasible?
Well, I think the other issues, the Glenmuckloch application has been referred to.
Well, we'll come on to Glenmuckloch in a moment, because that's slightly to the south, but insofar as this area is concerned, the SPA area of the Northwest Lowther is concerned, is that a realistic or feasible prospect in your professional judgment?
No, it's not.
Let's then turn to Glenmuckloch Wind Farm, which is slightly further south. What can you tell us about that? That was said to meet the Northwest Lowther area and to be an area where turbines could be located and or increased in height, I think, taken broadly.
Well, it's on the plan just northwest of Kirkconnell, but it's out with the SPA. There was an application for 8 turbines. The recommendation from officers was one of refusal. Nevertheless, it was approved by members at committee.
And why was refusal recommended? For what reasons?
I'd need to go into that, but there's certainly landscape and visual reasons there. The related point on that application is that there was a subsequent Section 42 application to increase the tip heights from 133 to 149.9 metres. Again, it was recommended for refusal. on landscape and visual grounds, but again the committee resolved to approve it subject to the applicant entering into a legal agreement. So the planning history here demonstrates that the unit is difficult. Its SPA coverage is extensive. There are cumulative issues with the Nithsdale Valley. Planning history demonstrates prospects are not positive and go to high risk for this particular unit, a restrictive scope, I would conclude.
Sorry to interrupt you. You said, Mr. Bell, there was a Section 42 application. It was approved by committee subject to a legal agreement. Has a legal agreement been concluded yet, or is it still minded to grant?
Still minded to grant, is my understanding.
And how long ago was that was minded to grant? Can you remember? If you don't know,
I can't remember. I'd need to check the papers.
We can come back to that. Now, what do you, as a professional witness, make of a situation if the council suggests you could go to the area of northwest Lowther, as covered effectively by Glen Mucklock, to erect wind turbines in circumstances where the officials are recommending refusal?
I fully accept each case has to be treated on its merits, so one cannot assume that that would be the case on another application coming forward, accept that. But I think when one fairly looks at the extent of constraints in that area, it is not one that I think has reasonable prospects of success for commercial scale wind.
Would that be in any way connected with the proximity to the Nith Valley, cumulative effects, as well as any effects there might be on the SPA?
Yes, all these factors.
Now, if we may compare and contrast that situation with the NLEI site, what do you say about the planning status of our site, Mr. Bell?
I think I've set out some of the fundamental attributes of the site in my policy evidence, one being the site is Group 3 as per SPP, or could be regarded as such. Of course,
it's very, very fairly accepted by Mr. Wimble as being a Group 3 area.
Yeah.
So there's no difference about that.
I think that it's a starting point, and one needs to look beyond that at the development management considerations that then apply. If we look back in time, the Council had, in 2014, identified cumulative sensitivity zones in the interim spatial framework. That were the
and is that in document NLEI 22?
I think it is, yes. So we would, the North Lowther site is out with that. North Lowther.
And just on that, is it accurate to suggest that the area that was cumulatively sensitive was both south and west of our site?
Yes, that's right. Also, the aviation matter with regard to Lowther Hill, there is a suspensive condition proposed on that. Spango application we looked at before was not able to achieve that. Earlier in this inquiry, we've heard the discussion of 10-kilometre setback distance. Insofar as that's relevant, it's probably not that relevant given it's a South Lanarkshire supplementary guidance point, but insofar as that matter has been aired, in my view, based on the landscape evidence, there is a fit with the pattern of other development that is acceptable. I think also an important point is that the North Lowther scheme has budget on the Eskdale Muir matter, the seismic station.
Could you just explain that, please, Mr. Bell?
The
Eskdale Muir.
The Eskdale Muir seismic station is established largely to monitor compliance with the Comprehensive Nuclear Test Ban Treaty, to identify illicit nuclear explosions. That's its primary function. It has a no development zone of 10 kilometres and a consultation zone of 50.
50 kilometres.
That's right. That's right. Now, the Ministry of Defence will object to any cumulative impact of developments that exceed the budget, of what's called the noise budget. And the North Lowther site is on the edge of the 50-kilometre zone, so it doesn't take up much budget. And
as a matter of fact, is there an objection from the MOD for these reasons?
no, there's not.
There is not.
It's not. But to contrast that, there is an application called FAWSIDE, F-A-W-S-I-D-E, which is much closer to Estill-Muir, which has taken up approximately, my understanding is about 200% of the noise budget. And it's still not got enough. And when you consider that the North Lowther development could deliver almost 150 megawatts of capacity for a tiny proportion of the noise budget compared to other developments such as FAWSIDE that is 300 megawatts but requiring much more than the existing budget. There is a term bang for buck, and that was aired in quite some detail a number of years ago at the Newfield inquiry, another inquiry in Cumbria that I did, so that I appeared at. So the point I would make is that the North Lowther project is ahead of other projects. It has budget, and no objection as such from the Ministry of Defence. So in terms of the public interest of achieving installed capacity for minimal impact on the noise budget, I think that is an advantage that can be added to the others that I've covered there in terms of contrasting that position.
Can I just ask you this, Mr. Bell? In terms of Estill-Muir, as things stand at the moment, what is the extent of the prohibition or sterilisation of development for wind farms in terms of distance?
50 kilometres.
Are you saying that as things stand at the moment, the prohibition distance is 50 kilometres?
At present, because the noise budget is exceeded, that is the case.
What then does that mean for any suggestion that there might be wind farms located in or near Estill-Muir or areas to the east of our site? Would they be prohibited or not?
They would be, and that's where there is the tension with the capacity study and identifying capacity there, where there is the long-standing constraint of Estill-Muir.
Is that referred to by the Council anywhere? Do they know about it?
To be fair to the Council, yes, it is acknowledged in the capacity study.
So that any suggestion of wind farms within 50k of Estill-Muir as things stand would be prohibited because of the Estill-Muir situation, is that correct, or interest?
That's correct.
Sorry, I'll just jump back slightly. You said the capacity study, is that the draft capacity study?
Did I say draft capacity study? Right, okay. It will be the draft, that's the one at large now with us, yes, the draft capacity study. Need to check whether the wording on Estill-Muir as a constraint remains in the draft. I'm sure the Council will.
So drawing all of that together, Mr. Bell, what does that mean about the potential for wind farms actually being constructed in or near our proposed site?
I think when one takes the Lowther's units in the round with those constraints, this is a substantial area of Group 3, which, as a starting point, is a strong attribute of the site in terms of its deliverability. And it goes back to the point of the need case in terms of, and the government's made it very clear on the advice of the CCC, current policies are not adequate. In short, we need as much as we can get, as quick as we can get, where it can be accommodated. And the attributes of this site point to that acceptability of accommodation.
And can I just try and simplify it for my benefit? If we move west from our site, we're in conflict with an SPA and a triple SI. Is that so? If we move south from our site, we fall into the area identified previously as an area that was cumulatively sensitive. Is that correct?
Yes.
And if we move east of our site, do we fall into an area that's in conflict with the Eskdale-Muir issue or interest that you have outlined?
Yes, and deeper within the scenic area.
So that if a wind farm is to be constructed anywhere in the Lowthers, can you indicate where you say it could go except on our site?
These conclusions underpin the suitability of this site.
And what weight do you say should attach to these factors that you've just outlined?
I think in the overall planning balance, they are all material factors in play that point to conclusions in terms of whether the development can be accommodated and whether this is the right place, as per the language of SPP.
Well, no doubt we'll return to that. Mr. Mundell, who seems to be featuring large this afternoon, Mr. Bell, said that the Community Council at Sanquhar have a blanket policy to support or not object to wind farms. Is that factually accurate or inaccurate?
I think I picked him up 2 or 3 times saying that. It's simply not correct. I went on myself to the consent unit website this morning and downloaded the Community Council's objection to Sanquhar 2 wind farm on the grounds of landscape and visual matters and on the grounds of lack of community engagement. And the letter states that was a unanimous decision by the Sanquhar Community Council made on 18th of April 2019. So it's not something that's just happened in the last few weeks that's been missed. It's been a long-standing objection.
And do you think, therefore, it's appropriate simply to have dismissed the Sanquhar Community Council support for our scheme as effectively something that they always do?
No, not correct.
Community buyout, can you bring us up to speed about that, please?
In terms of the community land buyout by One Lockhead Community Trust that's been mentioned, and it was discussed a number of times yesterday in evidence, I think it's very important at this inquiry to make it absolutely clear that it's not a land use planning matter that's engaged in the consideration of this wind farm application. And I think there was what I certainly picked up yesterday, there was a danger of conflating the two matters. And whilst it may well be a matter that's foremost in the Village Council's mind, and I understand that, but we need to be very careful that we don't mix that up with the merits or otherwise of the application subject to this inquiry. And my understanding is that the land area in question that may be subject to the buyout is an entirely separate landholding to the wind farm application area. The applicant has no involvement in the community buyout. It's a matter for the landowner and the community trust. What has been touched on in evidence is the opportunity that could be there from some of the benefits of the wind farm to assist the trust in meeting some of its development aspirations in the event that the land is acquired. And I understand that the Village Council was engaging consultants on what that vision may be in the future. That's my understanding of the position.
Thank you. A more minor matter. Buccleuch, are they the applicant or are they the landowner, and what, if any, is the position?
Buccleuch Estate is the landowner. In my inquiry report at section 1.3, I set out the position clearly, and specifically that in May 2019, BIVA UK Limited acquired Forza Energy's renewables team in the portfolio of projects that it had, including taking full ownership of the North Lowther project. So that's set out in the inquiry report.
And as a result, is it accurate that Buccleuch Estate may indeed be the landowner, but is most certainly not the applicant?
That's correct.
The applicant is and always has been NLEI Limited. Is that correct?
That's correct.
Now, contamination remediation, which evidence has been led about, do you have anything to add about that, Mr. Bell?
I think one benefit that may result that in terms of data availability as a result of the development, subject to consent being forthcoming and that data being established, and that is certainly something that could be made available to inform any mining legacy restoration actions that was touched upon in the evidence earlier. So, indeed, the estate and would be willing to work positively with various stakeholders in that regard should consent be forthcoming.
Climate emergency declaration by Dumfries and Galloway Council. Have they declared such an emergency, and what are the effects of that?
Yes, my understanding is that the council declared an emergency within the Dumfries and Galloway Council area on the 1st of July. So there are various actions coming out of that, and no doubt we'll hear from the council on that in due course.
And does that tend to add to our need case or detract from it?
I think it adds to it, given what I was saying earlier in terms of that being declared at different levels of government.
Now, one final matter, I think it is, Mr. Bell, the hen harrier officer, if I may call him that. Is that related to the development, and what weight should the reporter put on that, as we say, material benefit? What do you say about that? What's your evidence?
Yes, the matter of the conservation management plan is set out in summary form as one of the key benefits of the development. And in terms of the weight to be attached to that, it is material in my view, and it should attract, given the evidence of Mr. MacArthur, now that's taken, I would say, significant weight as a benefit. I think this is, of course, different to a planning case under the Town and Country Planning Act, where it may be said, well, is that absolutely necessary for the development to go ahead, given it goes beyond standard mitigation and its enhancement? And one might say, yes, that may not meet that necessity test. I think that would be fair to say. But insofar as it's relevant to planning and to the development, whether it's enforceable and precise and so on, these matters could be addressed by way of a condition. And I think where I've had experience before of a condition being proposed that is not perhaps meeting all the tests in the circular 498, there has been reliance placed on section 36(5) of the Electricity Act, which gives discretion to ministers to attach conditions as they see fit. So it may fall within that category in this case. So in my view, it would be appropriate to place weight on it, and there is a mechanism by which the matter can be secured.
Fine, Mr. Bell, thank you very much. No further questions at this stage. Thank you. Sorry to take so long, sir.
That's all right. Mr. Finlay, bring your hands. Cross-examination.
Thank you. Just a quick point on Sanquhar Community Council, because I'm concerned about the weight that may be placed on it. Could you have a quick look at their initial letter of support, which is CD 228? Sure, Mr. Innes will help you. It's just a small point, but you recall that I think you'll see that the substance of their letter, insofar as there is substance, is in the second paragraph. The group have had regular consultations with us and keep us up to date with the process regularly. Our community council is keen to support wind farm development in our area and work closely with developers to achieve this. So that appears to be a rather general statement, would you not agree? Are you able to help us why they made an exception for Sanquhar 2?
I can only suggest, and it's a suggestion because I've not spoken to them on this, but they were quite clear in the Sanquhar 2 objection that it was on landscape and visual grounds and a lack of community engagement. So one could assume that they were satisfied here with landscape and visual matters and that there had been adequate engagement.
No, Mr. Bell, look at the letter. It says it's keen to support wind farm development in our area. That's a very general statement, is it not?
It is.
Yeah. Thank you. And it says nothing, it's impossible to discern from that letter the extent of consideration given to the proposal, isn't it? There's no mention of any particular at all.
Yes.
Thank you. Could we then turn to your precognition, please? And what I'm concentrating cross-examination on is matters that may have changed in the policy and planning background, which has been well rehearsed in many decisions, including most recently at Harryburn. So I'm not intending to go over that again. You drew attention and evidence in chief to the document entitled Protecting Scotland's Future, NLEI 27. It's right to say that wind energy features 12 times in that document, but on each occasion it's offshore wind. As I understand it, onshore wind is not referred to in that document. Can we agree that?
Yes, I think it's important to recognise that the focus on offshore wind there is because the government hasn't yet prepared an offshore wind policy statement. They prioritised the onshore wind statement, and what this document flags is that they will now bring forward the offshore wind statement, which follows it.
But obviously the Scottish Government will know its own mind, but in terms of we're looking for its policy on onshore wind, as you've just indicated, we should be looking at the onshore wind policy statement, which we will do. That's correct, isn't it?
Yes, that's right.
Thank you. And there's no suggestion in that document of any change in the, if I can call it the planning balance. I'm not restricting it to just planning applications. I'm including Section 36 applications in that too, but in the balancing exercise between environment and onshore wind, is there?
Not specifically.
No, thank you. If we then put that to one side and pick up your report, and we go to your Section 2, which is the Renewable Energy Policy Framework Update, you refer to the Committee on Climate Change report, which is CD 5.33. That is and I'm not diminishing it, but that's a technical report, is it not? Indeed, that's what it says in the title. And it doesn't attempt to balance the environmental impacts of any of the energy initiatives that it is looking at, such as onshore wind, offshore wind, or any of the other or green initiative. It's not a balancing document. It's not a criticism of the document, but it's just not its purpose, is it?
That's fair.
Thank you. And the same could be said for the two further reports you refer to at 2.3, that is the progress report to Parliament and the progress in preparing for climate change document. They're similar nature, they're important documents, don't wish to undermine that, but they're not seeking to provide advice on the balance between the impact of onshore wind on the environment, are they?
They don't provide advice on the balance, but they inform decision makers who will be striking such a balance, I would suggest.
Yes. We have a... trying to find it now. A statement of agreed matters on planning policy, and we're agreed that there is significant weight to be attached to that. You're not seeking to the need for renewable energy. You're not seeking to go behind that statement of agreed matters, I presume.
No.
Thank you. If we go to the 2.5 climate emergency, declarations of climate emergency draw different responses from different people, but again, there's nothing in what the First Minister said about the climate emergency which tells directly on the balance that we've just been discussing, is there?
No, there's not. But again, I would say that that is a matter that's material that does inform decision makers who will be striking a balance.
Absolutely. And if we then go on to your recent decisions section, which is 2.6, I would like you to have a look at the onshore wind policy statement, which is CD 513, which I've now just lost. I have to bring that up. If you go to paragraph 24 to start with, it's talking about the technology shift towards higher turbines, but that may present challenges when identifying landscapes with capacity to accommodate larger scale development, as not all will be suitable. So it's making it clear that there will still be some locations which are not suitable for the larger turbines.
Yes, fully accept that.
And then paragraph 25, it says the Scottish Government acknowledges the way in which wind turbine technology and design is evolving and fully supports the delivery of large wind turbines in landscapes judged to be capable of accommodating them without significant adverse impacts. That is the Scottish Government's test, isn't it? The lack of significant adverse impacts. And I would accept, in order to move things along, Mr. Bell, that that is made in the context where the Scottish Government, SNH, Dumfries and Galloway, and the applicants are all aware that all commercial scale wind farms will have some significant adverse impacts. It's whether the landscape can accommodate them without those impacts.
Indeed, yeah, that's absolutely correct, and welcome the clarification on the use of the term significant adverse impact.
Yes, I wanted to make that clear because I'm not suggesting it's never been part of either of my clients' case that simply because there are significant adverse impacts the wind farm becomes unacceptable. And I think that is clear. Thank you. And then individual decisions at the end of paragraph 25 on wind turbines and wind farms will continue to be considered on a case-by-case basis. And that's indeed why we're here today.
Indeed, yes.
I'd suggest to you there's nothing in that which you highlighted a moment ago as the up-to-date Scottish Government position on wind energy which suggests a change in the balancing exercise when you're evaluating environmental impacts on one hand and the need case on the other.
I think that's where it comes down to a case-by-case basis on the range of material considerations that is before a decision maker. And whilst I agree with these high-level general principles for the planning system, we need to deal with the material matters that make up the positives in terms of the need case, but also the evidence that is specific to the case. So that's fully in line with case-by-case basis. But in terms of the balance, it will be for the decision maker to strike that balance on what is before him or her. And the amount of weight to be attributed will vary, and it doesn't need specific direction in a policy statement to direct a decision maker as to that balance. It's a classic planning judgment that needs to be struck.
Yes. Can I ask you then to look at the Blairmore decision, please, with which you will be familiar? It's CD 7.03. Or 7.3, I think would be the quickest way of saying it. If we turn to paragraph 29, when it says the appellant argument, I think it was you in this case, wasn't it, on policy?
Yes, it was.
And I make that point for a reason, not just to make a cheap point. Argue that the new 2030 targets for new renewable generation represented a step change in policy. Now, if we look through your report, you don't actually suggest in this case, or repeat that argument, that there's been a step change in policy. You don't see that wording in your report, do we? Unless I've missed it. You see similar wording, and I'll come to that in a moment, but not a step change.
No, I use the government's wording now, my 2.8.18, which is transformative change. So the government wants a significant change in the approach.
Well, it's quick and decisive action, but it's not suggesting there that the outcome of any case-by-case assessment should be different, I'd suggest to you.
No, but if one takes the volume, consistency, the sentiment that is reflected in the documents that have come out, including the climate emergency, if one's to say, is there any change that will go to the matter of planning judgment in a decision? Now, the Council may say there's no change at all. We just need to rely on SPP of 2014. I say that is the wrong approach, that it is open to decision maker to look at the broad corpus of documents that exist there, the messages that are in them, and to reflect, is this global heating emergency something that engages in the planning system, or is it not? My view as a chartered planner is it does. There are material matters that come to a planning decision. They're not overriding, but I don't use the word step change. In fact, it wasn't purposefully because it had not been accepted. I'm simply relying on the government's wording in that there is a strengthening, in my view, of the need case, and it's how best to express that.
Well, I'm surprised you say it wasn't purposefully, because in your planning statement of April 2018, you do use the word step change. There are paragraphs 2.6.6, 2.6.10 and 4.22. You have changed the wording from your planning statement of April 2018 to your report today, and that was purposely done, was it not?
It was insofar as I was referring to more recent documents.
Mr. Bell,
that's my position.
You were alleging a step change in April 2018, and you're not doing it now.
I'm comfortable with that language. It's not that I'm uncomfortable with it. I think if one adds up the collective position in these new documents and positions taken by government in statute, and Scotland now has the world-leading targets, the most stringent in the world. To say that that's not a step change over the 2014 position in SPP, and I don't know what would be.
Well, it's a question whether it's a step change in the decision-making process that Scottish ministers advised by this report have to make on this case-by-case basis. If we come back to Blair Moore, the reporter there said that I agree in paragraph 30 that Scottish Government energy policy is strongly supportive of renewable energy proposals. No doubt the target for 2030 is ambitious. And you, that inquiry had not a similar list, but an equivalent list of new announcements supporting your case for a step change. But he says this in paragraph 31. It may be that the appellant's point is intended to go further, that a strengthening of the case for renewable energy means that other considerations, such as environmental protection, must have less weight. Is that your point at this inquiry, Mr. Bell?
No, I mean, the reporter here, Mr. Seaton, asked me that exact question at an inquiry in October of last year. And my view was that it comes down to something town planners deal with day in, day out, is balancing different considerations. And if the weight is being increased on one matter, then that goes into play in striking a balance.
So are you suggesting there should be less weight for environmental protection?
No, in terms of whether it's Green Belt or an NSA or designations, then they have a level of protection that we're familiar with in the planning system. But in the same way that the need case might increase for housing, or it might increase for renewable energy, that is a matter that goes into the balance.
I'm asking you about one side of the balance at the moment, and I'll ask you a third time. Are you saying that environmental protection generally, not just specifically identified or recognised areas such as NSAs or national parks, should have less weight?
Difficult to say yes to generally, because that isn't right. I think one needs to look at the case-by-case circumstances, and where you have largely Group 3, largely not designated, and the various other environmental attributes that I went through with Mr. Steele, that points to a position, in my view, where that intensified effort on the need case that was set out by the reporter in Penclone comes to bear. That where you have that mix of circumstances, that is where the need case tips it, in my view, into an acceptable position. So it's not a general policy position that I'm drawing upon.
Mr. Bell will be here all evening if you don't listen to the question. The question was straightforward. I've asked you 3 times now whether environmental protection in general terms should have less weight.
I said no to that.
No. Okay. I'm grateful. Thank you. We can move on. So I can then simply note, if that's not your case, I can simply note what the conclusions the reporter drew up to paragraph 34 on that and move on from there. You mentioned that Penclone decision, effort being intensified, but an intensification of effort is not the same thing as changing the planning balance, is it?
It's not the same.
Thank you. Then move on from renewable energy policy to your section 3, which is your reasons for objection, and you quite fairly drawing on views and others, and I'm not going to go through landscape and visual matters again with you. 3.5.4, just a small point. You're saying the development, which is 147 megawatts, can draw significant support from the policy criterion. And I was just looking at other decisions. Penclow, which I accept was low, was just under 70 megawatts. I think the reporters said a worthwhile contribution. Dornell, which in fact I think is bigger, both cases which I think your side have cited in support, 198 megawatts. The reporter simply said clear benefits. Are you importing anything different from that by your word significant support? Valuable contribution, clear benefits, significant support. Are they similar ways of saying the same thing, or are you importing something different by the use of the word significant? And if so, what?
I think I can give you clarity on my position on it.
No, well, I'm just after your use of the word significant, whether you're suggesting that there should be more support than was given at, for instance, Penclow, which is the decision you've referred to and you're familiar with, and also Dornell, which I'm sure you're familiar with too. Are we looking at something different from that now, or is there any change?
No, I think it's no significant change in that, but I think when you get to close to 150 megawatts of scale scheme, there's not that many schemes coming forward, largely in Group 3 areas of that scale.
Understand that, but I can move on. Another short point, 3.6.15, talk about schemes that have been successfully integrated in RSAs and SLA designations. And then you give a list. We can agree that such a designation is not an embargo on schemes.
Yes.
We can also agree it's not irrelevant, and you just need to look at the Harryburn decision to see how it can be relevant.
Yes,
it's an adverse impact. Thank you. Then, if we can then go on to LDP2 and the SG and the wind capacity study. Now, as I understand it, your client has not put any, didn't make any consultation response to the consultation exercise for the draft SG or the draft wind capacity study. Is that correct?
That may be correct, yes.
I mean, I take that from an answer given last week, I think probably by Mr. Van Grieken, but it could have been Mr. Welsh. As far as the wind capacity study is concerned, the changes between that and the adopted study are minimal. They're really typographical errors and a tightening up of language, is that not the case?
That's fair, I think, yes.
So insofar as weight in terms of the wind capacity study is concerned, you're not talking about a brand new wind capacity study. You're talking one that until Friday of last week was part of the adopted development plan and it remains unchanged. So surely giving little or low weight to that is the wrong approach.
My general view is that capacity studies should be afforded limited weight.
Well, I'd suggest to you that that's the wrong approach for the reasons I've just given. In terms of the supplementary guidance, parts of it again are new and parts of it are, but the majority of it is unchanged. Again, well, let me take this in two stages, given your last answer. That would be a relevant factor to take into account when according how much weight to give that, at this stage, non-statutory supplementary guidance, would it not?
Sorry, just to clarify your question.
That parts of it were simply taking forward existing guidance and parts of it were changed.
Yes.
Thank you. And that the reporter also has to bear in mind, and I think you'll hear this from Mr. Robinson yesterday, that there's now LDP2 is adopted. There will be a programme for adopting that supplementary guidance, and I believe at this stage it's to go to committee in November, and the intention is to adopt it in January. If that timetable is adhered to, it will form part of the development plan more likely than not, will it not?
If that programme's followed, then yes.
In which case, that supplementary guidance and the wind capacity study will have more than limited weight, will it not?
It may stretch to moderate weight, but I think I've set out a range of decisions in which reporters have found entirely contrary findings to what are clear positions in capacity studies. So that goes to my view on the matter of weight that should be placed on it.
Yeah, no, I understand that, and again, it's been no part of either of my clients' case that simply because you conflict with a wind capacity study doesn't mean that you cannot be found acceptable. But I'd suggest to you that it is part of your client's case to diminish the weight that should be given to such capacity studies. And with that, in trying to sort of help focus that argument, could I ask you to turn to the LDB2 reporter's report, which is in CD 611, although I think in your paragraph 388.8 you've referred to CD 612. And we're looking for page, I think it's electronic page
179?
It's electronic page 183 in my version, but it's actual page 179, absolutely.
I've quoted it possibly in my hearing statement at page 41.
You quoted 3 of the paragraphs, but it was 2 paragraphs before that I wanted to go to. It's page 179 of the document, and I think, well, it's certainly in my version, electronic page 183, because they don't necessarily coincide.
Okay.
In fact, we can start at paragraph 52. The reporter refers to the Scottish Government's document Onshore Wind Planning, which must take the prize for being one of the few planning documents I don't think is a core document in this case. This describes landscape capacity studies as supportive studies relevant to development management and for planning policy related to natural heritage and landscape. And then at 53 it says the FAQ document describes the role of them, and it's as being to establish a better view of local landscape sensitivity, and I understand you would agree with that, and that's what Mr. Welsh and Mr. Van Grieken majored on. Secondly, to identify acceptable levels of landscape change. Do you accept that that's a proper role for a landscape capacity study? Well, it doesn't limit it to that extent, but here are. Identify cumulative effects and set objectives and guidance for managing those effects. That's another proper role for it, is it not?
We can identify possible cumulative effects that might arise, not exact ones. Clearly, they will come forward with applications as they come forward.
And it can identify scope for further development.
That is where there's been great debate on the role and use of capacity studies as to the extent to which it does identify scope for development, whether that is an outline starter approach or whether that is a hard and fast position on scope.
Well, yes, and let me make it clear to you. Dumfries and Galloway don't suggest that it is a hard and fast approach, because the very document itself says, I think as your landscape witnesses have pointed out, that it's no substitute for, and I'm not quoting, but I'm paraphrasing, no substitute for a case-by-case consideration. And it won't surprise you that that's the same approach taken by the reporters in the Limekiln case with which you're familiar, and indeed by this reporter in the Upper Sonacan case, with which you will both be familiar as you were both involved in that inquiry. So that it's not just a sensitivity study, is it? And this capacity study is not just a sensitivity study.
It's not just a sensitivity study, but there are issues around how capacity has been arrived at in terms of how it defines capacity. I don't think it's necessary to delve into that, but I think if you're being clear in the Council's position is that it's not a hard and fast position on scope, then that is fine. I think there are other parts of Scotland where a different position is often taken and used in decision-making in that way. And I think it comes down to my position at the end of the day that it's a starting point, it's helpful in identifying landscape sensitivity, and there's a view taken on scope, but that has to be placed in the perspective that you've set out.
Well, again, I'd suggest to you that that is indicative of an approach that every witness so far for the applicants has adopted of trying to demean the importance of the wind capacity study. Although you've gone further than Mr. Welsh has, you've accepted it can go beyond local landscape sensitivity. But I suggest to you that it can be of greater importance than you've indicated, subject to the caveat that we're both agreed on, that it's subject to the case-by-case LVI assessment.
Yes, I think that's key, that last point in terms of the specific development assessment.
And then, can we take it, lastly this, in your additional questions, Mr. Steele was developing a line about where you could possibly have wind farms in and around this area. I think that perhaps assumed, although I'm not quite sure the basis for the assumption, why there should be, particularly in this area, wind farms. But Eskdale Muir and the restrictions in that did not feature in the Harryburn case, did they?
I don't think they did. I was there for the policy hearing. It wasn't discussed. That was up to the applicant then to raise it, and they didn't.
The wind capacity study is not to be criticised for not referring, because it's a landscape and visual document, not to be criticised for not referring to SPAs or SSSIs, is it?
That is right, and the introduction does make it clear that the capacity study has to be read in the context that there will be various other constraints and factors that go into planning decision-making.
So it's not
hence, I think, the importance of me placing that wider context for the Lowther units in terms of the other planning matters that come into play.
Okay, so it's not a criticism, a fair criticism, the wind capacity study, to say that it hasn't taken account of the SPA or the SSSIs, is it?
I think that's very fair, and probably underpins why the reporter sought to take it out of the policy in the report of examination, because I think that might elevate its importance over and above possibly other considerations.
Well, I think that's a separate point with respect, but when any wind capacity study anywhere is just a landscape and visual study primarily, and whether you have technical constraints such as Eskdale Muir, and I think there is one reference to that in the current draft, or not, or reference to, there can be no criticisms of lack of reference to SPAs or SSSIs. And indeed, that's not a criticism that's been made by your clients in respect to the consultation exercise.
Yep. And I think that's where the word capacity has to be placed in that context, that there are other factors that will come into play. So the true capacity of an area that might be delivered is pursued in the wider planning system beyond that document.
And the reporter can also record that your clients haven't suggested that the boundary between the, I can't remember the name of the units, but the unit that the site sits in and the unit to the north is incorrectly drawn.
No.
Nor have your clients suggested that the general guidance within the capacity study for the unit in which your client's proposal sits is incorrect either.
There's not been a specific position put forward because the application has sufficient force to present a different position.
Yeah. No, I understand that, and I understand that the way Mr. Welsh put his evidence was not to challenge the assessment of the unit in which the development sits, but to assess whether its guidance was particularly appropriate to the particular site of the application. So I accept your answer on that, but it is important to note that there's been no challenge to the wind capacity study or suggestion that it's at fault in any consultation exercise?
No, there may be other parties who have made a number of representations in that regard.
Thank you very much, Mr. Bell. Sorry, I've exceeded my time, but only by 5 minutes, I think.
Thank you. Now, Mr. Goffrey, Ms. Gibb, do you have some questions for the witness?
Mr. Edwards, I have just a couple of questions of clarification, if I may. Firstly, Mr. Bell.
Sorry, I'll interrupt you there.
Sorry?
It's not clarification at this point. You're allowed to cross-examine the witness.
No, I have no issues with cross-examination. Anything that I wish to put will be put in our final submissions on and before the 21st of October.
Okay, I don't want something coming out.
No, nothing. Well, I may ask Mr. Bell one or two questions then.
Yep, as long, again, I keep caveating this, as long as it's something that's come out of Mr.
I will rely on you to keep me on right on that matter. Mr. Bell, you stated that you had, sorry, I've lost the place here. There it is. You stated that you had provided lots and lots of consultation throughout the area of this development. In particular, you made much to do about the consultations held in Kellerholm, Kirkconnell and Sanquhar. Do you have any documented evidence that tells us of the numbers who attended these consultations? This should be excluding the number of representatives from the developers.
I don't know the answer to that at the moment, but it may be that in the pre-application consultation report that there is a record of the attendees of the open days. It's usually information that's included in these reports, so I'd need to check within CD 1.5 if that is the case.
I wonder if you could oblige by checking that for me. Thank you.
Thank you. If I could have CD 1.5. It is quite a long report. I'll need just a few minutes or to have a look at it.
It may be me, but I wonder if Ms. Gibb could just perhaps repeat what the question was. I think I lost it.
I'll summarise it. It's essentially asking how many people attended those 3 public engagement events.
So I wonder whether this is an answer Mr. Bell could give tomorrow morning if it save him leafing through a document at 5:30.
Yeah, I think that's acceptable.
I'm happy to do that. Thank you.
Very briefly, Mr. Bell, the thrust of Scottish energy policy is to encourage and promote renewable energy, is it not?
Yes.
Renewable energy is a term that applies not only to wind turbines but to other forms of renewable energy. Is that the case?
Yes.
So that the thrust is for renewable energy, to promote renewable energy, and not just wind power. Is that the case then?
Yes, that's correct. There is the onshore wind policy statement that was referred to in the previous piece of evidence. And what it does say, though, is that onshore wind has a vital role. Its contribution must continue to grow. And it's crucial that specific technology in terms of the government's goals for a decarbonised energy system. That's paragraph 3 of the onshore wind policy statement. So the government's not saying that about solar energy. It's not saying that about biomass. It's not saying that about tidal arrays. So onshore wind is singled out as having a specific vital role. That's not to say the other technologies aren't important, and indeed there is a drive to develop more offshore wind, but onshore wind is singled out as a specific technology that is important.
Thank you, but you did make the point that other forms of renewable energy have to be considered within the overall sort of energy equation, if you like.
Absolutely, yes.
Thank you. I've got no further questions.
Right, Mr. Bell, just a few questions for you. Just picking up on what you've said in response to some of the questions, I just want to confirm, in terms of the lime kiln decision, I think you said SNH objected in terms of landscape and visual, but my understanding is they objected in terms of the impact on wildland. Is that correct?
Yes, that's right.
And in terms of deliverability, is there any indication of, should this proposal be consented, when it might deliver the benefits that you've described?
The grid connection agreement is for 2024. So, assuming the report goes up to ministers, say in towards the end of this year, there's a decision in 2020. Then construction could proceed to meet that grid date. So it could be up and running by the middle of the 2020s, contributing to the 2030 interim target and others.
Okay, and nothing like putting pressure under me to complete my report by the end of the year then, sure. Now, you mentioned other capacity studies in Scotland, and that other authorities had run an argument that what was said in there is essentially final. Is a difference here that the capacity study is part of the development plan, whereas in other authorities it's a non-statutory consideration?
That has not really been an argument that's been advanced because it's statutory. I always thought it would be. But in Argyll and Bute, the statutory basis hasn't really featured prominently, although there it is highly constraining. Another area is Murray Council, where it is statutory. But in both of these areas, the capacity study is used, in my experience, in cases I've dealt with, in a way that the language used by planning officer, for example, I won't name any particular area, but it's been the development departs from, the development is not in compliance with, and it doesn't adhere to the guidance. Now, I'm not suggesting Dumfries and Galloway Council was using those terms, but those terms are used elsewhere. I think that's the real difficulty that developers have in the way it is used and applied. They can be used and applied.
Okay, thank you. Now, can you comment in relation to Mr. Godfrey's assertion that the proposed wind farm would need to be constrained and subject to constraint payments?
Yes, I can.
Here I'm referring, I think Mr. Godfrey's provided details from GridWatch, which show constraint payments to the Clyde wind farm, which I think, if I'm right, would have the same grid connection point at Elvenfoot as what's proposed here.
That's right. I've had a look at Mr. Godfrey's position on this, and it is right that there were constraints payments, particularly in 2018, as Mr. Godfrey has raised. But one of the issues was that the interconnector link between Scotland and England had a number of outages at that time. and it's the Western HVDC link, which connects broadly Hunterston with Deeside, which is near Liverpool. And the link is rated at over 2 gigawatts. It's 2,250 megawatts. And there were various faults through 2018 in particular that led to the situation where National Grid is trying to balance the system. And if that's in a situation where there's high wind coverage in Scotland and there's a lot of generation, and there's low usage of that power in Scotland, that the balancing mechanism kicks in where operators have to constrain the generation. So schemes like Falago Rig, Paul's in East Lothian, Paul's Hill in Murray, Clyde, may have to be constrained off the system so as to not overload the Anglo-Scottish interconnector, the overland link. So I think that is the position that gave rise to that particular timing of constraint payments. But constraint payments are part of the normal balancing mechanism that government consulted on a number of years ago, and they are paid not just to wind energy developers, but to fossil fuel providers as well, to constrain off the system. I think we also need to bear in mind that SPP makes it very clear at paragraph 165 that grid constraint matters are not a material planning consideration. So hopefully that gives you some information on the circumstances that arose back in certainly 2018 when there were relatively high constraint payments, but it's not a material matter.
Okay. You told me earlier that this isn't a planning issue, it's a Section 36, and therefore there are different considerations that I can take into account, or ministers can. So in that set of circumstances, what SPP says in paragraph 165, can I discount that and I can take into account constraint payments or constraint over a wind farm operating?
I would suggest no. That I'm not saying that planning policy is not material. That is, but certain of the statutory provisions, such as Section 25, and some of the guidance that applies to planning applications would not be applicable in terms of the legal approach to dealing with this application. But I've never seen, either in a reporter's decision or, to be fair, a planning authority determination or a Scottish minister's determination, grid constraints being used as a reason to refuse a wind farm application or another renewable technology.
Right. In terms of the South Lanarkshire Local Development Plan, could you comment on how or why that might be relevant as a consideration in this case?
I don't see its relevance, given we have an up-to-date LDP and full suite of relevant policies to deal with. I can't identify any matter that it raises that would be pertinent in policy terms, and I would question the legality of relying on a policy position in that plan.
I mean, you're aware it's been submitted as a core document, and there's a capacity study within that authority area as well. I've been asked to walk routes and look at advantages from within South Lanarkshire Council, and they've also objected. So on that basis, is there any comment in terms of how it would apply, or indeed I wouldn't apply the local development plan policies for that area?
I think landscape and visual matters would be potentially material for you as a decision maker to take into account, but to rely on a policy position from another local authority area, I would say no. I wouldn't be.
I'm just hypothetically here, if I found an impact on the special landscape area in South Lanarkshire, or from a viewpoint within South Lanarkshire, what then would I apply in terms of a policy test? Would I go to the Dumfries and Galloway Local Development Plan 2? Would I look at the South Lanarkshire Local Development Plan policy context? Or would I look somewhere else?
I think the policies that are in the South Lanarkshire LDP are for that area, not directly applicable to developments in other local authority areas. I think that's different from you taking a position on an effect on the wider landscape context, which would seem to be within the remit of what you could do, but not to rely on a policy position and express that in a justification for refusing consent for the application, should that be a conclusion.
Now, I asked some questions of the landscape witnesses in relation to the provisions of LDP 1 in terms of policy in 1 and the term in combination for cumulative effects. Now, I understand that terminology is no longer included in LDP 2. Is that correct?
I think that's right. Council can probably absolutely clarify that. I did hear that exchange, and my view was, in looking at that wording, that it was effectively meaning the cumulative position, not a technical landscape methodological difference from an in addition effect. And again, I think the council planners can probably explain that, and I'm assuming that they will take a consistent position to what I've just said.
So, may I assist if I can confirm that? In our understanding, in combination was equivalent to sequential or whatever. There wasn't making a point as to the difference between additional and or combined. So that it wasn't, because an additional effect might be an in combination effect in itself. Although the combination is the same word, it's used in a different context.
Simply for clarification, remember there were various questions to Mr. Welch on forestry in the area. I think it was going to be put to you that you could confirm whether or not there was a forestry management plan and what that plan meant for the application site. Could you confirm that there will be one, and can you confirm what changes there might be in terms of the forestry over the application site?
There is specific information on the forestry numbers, which I'm afraid I don't have it to hand, but I have made a note of the forestry areas in terms of forestry coming out and going back in. So,
could we helpfully leave that till tomorrow morning along with the community consultation then?
Certainly add it to that, because it's got specific figures which I'd like to provide.
I think it may be in Chapter 4 of the FEI, Chapter 3 or 4 of the FEI.
I'd made a summary note of it, which I can easily provide in the morning. In fact, actually, I've got the figures here, if I can give you the figures. The forestry, it is in Chapter 4 of FEI, it's paragraph 4.9. And forestry to be felled to accommodate development, 69 hectares. Or to be exact, 69.11. And then replanting of forestry within the existing forestry area, 32.5 hectares. And thirdly, compensatory planting, 36.1 hectares. terms of the forestry plan, I'll provide clarification if I can in the morning of that, if that's acceptable, sir.
Right. That's all the questions I have. Mr. Steele.
Thank you, sir. Mr. Bell, we need to be quick. Firstly, 2.8.18 of your inquiry report, transformative change is the word, or words plural even, that you've used rather than step change. Can you just remind us why you've used these words and if it relates to government wording when that came into force? 2.8.18, sir.
Yes, I've used the government wording on that.
And when did that government wording come into vogue or force, as the case may be?
That was post the Committee on Climate Change's position on recommendations for net zero targets for 2045.
When was that?
Post-May 2019.
Yeah. So is it any surprise that in documents that you wrote before that you may have used step change, but since the government started talking about transformative change, you've changed the lingo too?
That's correct.
Is there anything surprising about that?
No.
Could I ask you please to look at the Penclow decision, which is CD 7.44, Mr. Timothy Bryan, reporter. Could I ask you to look at paragraph 9.7, which I've not scribbled on, and whether that reflects or otherwise your understanding of the position?
Yes, that's my understanding and the reference I've made in my inquiry statement.
Could I also ask you, please, to look at the reporter's findings in relation to the local plan inquiry, CD 611, pages 179 and 180. These relate to the capacity study and a series of questions that were put to you about that. While that's coming your way, is the capacity study, does that relate to landscape and visual issues?
Yes, it does.
And are there obviously other factors of a practical nature that have to be taken into account as well as to whether a particular development, in this case a wind farm, can or cannot be constructed?
Yes, that's right.
Now, let's take it as briefly as we can, given the time. Was there an objection by, so happens, Fred Olson in relation to the issue of the capacity studies?
Yes, that's right.
And did the reporter make clear at paragraphs 56 and 57 as to his position about that? And perhaps you could just read out the bottom sentence at paragraph 57. And do you agree or disagree with that?
It is clear from the study itself that this is not to be viewed as a substitute for a site-specific assessment, but I consider it helpful to make this clear in the plan. Yes.
Is that your position? Do you agree with that?
Yes, I do.
Yeah. It's exactly your position. And was it for these reasons that the reporter recommended modifications to the plan to reflect that finding?
Yes, that's right.
Is that also something that you agree with?
Yes.
And in considering matters out with the capacity study, relying on the LNV, might other factors to be considered and attach weight be the existence of an SPA or of the nuclear monitoring station?
Yes, material matters.
And the standoff distance or exclusion zone associated with that? Would these be material considerations?
Yes.
Now, in relation to the question of constraints, firstly, do you say that government policy in SPP accepts that such should be considered as a material planning issue or not? What does the SPP say about constraints?
Specific constraints or just general?
The constraints of the top. Type, so sorry, that Mr Godfrey has put constraint payments, which the reporter was asking about.
Paragraph 165 is clear in stating that grid capacity shouldn't be used as a reason to constrain either areas identified or applied to individual decisions.
And do you say that's to be regarded as a material consideration, namely government advice in the SPP?
I do, yes.
And in any event, whether that's correct or not, although obviously we submit it is, was the issue one of a technical fault with the interconnector rather than anything else?
That gave rise to particularly high constraint payments in 2018, yes.
Because there were faults with the interconnector, physical faults, is that so?
That's correct.
Can we assume that they might possibly have been fixed and that issue would disappear if that is so? Would that be correct?
Yes, it's running at full capacity now, over 2 gigawatts on that particular link.
And is the critical issue, Mr Bell, that we in fact have a grid connection which, subject to a favourable decision, naturally, we believe that we can achieve in or by 2024?
That is correct, yes.
And does that mean, or does that not mean, that we would be able to contribute to certain imminent targets which are set in relation to renewable energy?
Yes, unlike other schemes that are consented, that rely on interconnectors such as from Shetland and so on, this is a scheme that is effective insofar as the grid connection is deliverable.
And indeed, is it effective, notwithstanding the lack of subsidy, which is an issue for others as well?
Yes, it helps provide that route to market.
So do you say that the existence of the grid connection and the time frame that we're talking about is a factor that weighs in our favour or weighs against us?
In favour.
Fine. Thank you very much, Mr Bell. No further questions in all the circumstances.
Thank you, Mr Bell. Right. Tomorrow, we're going to hear from Mr Robinson and Mr Godfrey on policy. We then have Mr Mundell as well in the afternoon, but I suspect that will be after SNH internal procedures. On that, I think we're only hearing, well, we'll be hearing firstly from Mr Halfhide. Is that correct? And then I'm assuming we may hear from one of your landscape witnesses, Mr. Welsh.
Well, sir, we intend to lead evidence both from Mr Bell in this regard and Mr Welsh, both of whom have got sections dealing with this. I suppose the question is who should be led first. I must say I'd rather thought that we would be giving evidence first about the matter, being the applicant, and also we're the ones that have been critical of SNH, but I'm in your hands.
It's got to that time of the day. So, yes, we'll hear from the applicant's witnesses first, and then we'll move on to Mr Halfhide, and then Mr Mundell, and then if we have time, we'll move on to have the condition session. Okay.
I'm beginning to get less confident about dealing with the conditions as well tomorrow, sir, and I'm now not certain we'll get through all the witnesses tomorrow, but obviously we're going to endeavour so to do.
Can I just throw into the mix that Mr Halfhide is not available on Thursday, so if we are getting to a stage where there's a risk he won't be finished tomorrow, we may have to reconsider the order of witnesses.
Well, I have no objection in party to beginning at 9:30 tomorrow. Is there any objection to that?
Encouragement, sir.
So we'll resume tomorrow at